Why don't we get started? Hello, everyone. Good morning. My name is Matthew Diller, and I have the honor of being the Dean of Fordham Law School. Welcome today to our virtual symposium, and I look forward to welcoming you back at the law school when we are able to. This is the 35th anniversary of the founding of the IPLJ and the 28th annual IPLJ Symposium, but of course, it's the first IPLJ Symposium to be a virtual event. The Fordham Intellectual Property, Media, and Entertainment Law Journal Symposium, Free Speech in the Modern Age, will be an in-depth conversation about a number of important contemporary issues affecting free speech that go beyond just the First Amendment. And really looking at discussions of free speech today is like drinking from a fire hose. Free speech is so much at the fore of what people are thinking about, talking about. It's a concept that is morphing and changing as our means of communication and means of expression change. And it is a fascinating area that's on the front page of the news every day. Today, we'll focus on a number of topics that really focus on the intersection of free speech and media, which is, of course, the connective theme of the conference. We have panelists joining us both from Fordham Law School and from neighboring institutions in New York City, but as well as universities and law firms across the country, including North Carolina, Texas, and Maryland. And today's symposium has three panels. The first panel is Banned Books, Pre-Publication Review in the Intelligence Community, and it will explore how non-disclosure agreements signed by current and former employees of national intelligence agencies affect the publication of books written by high-profile government officials, and how the current system of pre-publication review balances open discourse and national security interests. The next panel, Hitting Back, Slap Suits and Anti-Slap Statutes, will explore strategic lawsuits against public participation and state-level anti-SLAPP laws, which provide a mechanism for dismissal unavailable on the federal level. And our final panel, Celebrity Paradox, Copyright, Social Media, and Paparazzi Photography, will explore the conflict between ownership of a person's image and ownership of images of a person in the context of social media. Catherine Bolger, partner at Davis Wright Tremaine and an adjunct professor here at Fordham Law, who teaches media law, will deliver the keynote address. And I'd also like to thank, in particular, the symposium editor, Claire Marie Oxy, for organizing today's program, along with the IPLJ board, including editor-in-chief David Devich and managing editor Catherine Ballington. And of course, to the entire IPLJ Symposium Committee and staff and board. And my thanks as well to Professors Olivier Sylvain, Ron Lazebnik, and Abner Green for their help as moderators and in helping to develop and refine the panel topics and to identify speakers. I would now like to introduce symposium editor Claire Marie Oxy, who will say a few words and provide some logistical information about today's program. Take care and be well. Thank you for joining us.
Thank you, Dean Diller. Good morning, everyone, and thank you all for joining us this morning. I'm going to provide you some logistical information about this event and about getting CLE credit.
Good morning, everybody, and thank you for attending this year's IPLJ Symposium. I'm Catherine Ballington, a third-year Fordham Law student and the managing editor of our Intellectual Property Law Journal. Before I introduce the first panel, I would like to give a big thank you to Claire Marie, who put together this symposium over the past year. I'd now like to introduce Professor Abner Green, the moderator of our first panel titled Banned Books, Pre-Publication Review in the Intelligence Community. Professor Green is the Leonard F. Manning Professor of Law here at Fordham. He received his Bachelor of Arts from Yale and then attended Michigan for law school. After law school, among many other things, he clerked for the Honorable Justice John Paul Stevens. He specializes in First Amendment law with the focus on the free exercise and establishment clauses. He now has over 40 publications and currently sits on the Diversity and Inclusion Board here at Fordham. I could go on, but now let me hand you over to Professor Green. Please enjoy the panel.
Hello, and thank you, Catherine. Thanks to Claire Marie and all of you for putting this together. It should be a fascinating subject with many different perspectives. You all have information on the panelists, so I'm not going to further introduce them other than to tell you that the order in which the panelists are going to speak will be Christopher, and then Mary Rose, and then Ramya. Each of the speakers will get 10 minutes. Then the four of us will engage in a colloquy among ourselves for about 10 minutes, and then we'll have 20 minutes at the end for questions. You can type your questions into what I see on my screen is a special Q&A tab, and then we'll take the questions from there. So without further ado, Christopher, you are first up.
Thank you, and I assume everybody can hear me. Good morning. My name is Dr. Christopher Bailey. I'm a professor of law at the National Intelligence University in Bethesda, Maryland. I've been teaching national security law and professional ethics for about 10 years, and I'll be speaking for a few minutes about how the intelligence community pre-publication review process works. First, I would like to say that all statements of fact, analysis, or opinion are my own and do not reflect the policy or position of the National Intelligence University, the Office of the Director of National Intelligence or any of its components, or the US government. Second, I can tell you that this is a topic in which I have some interest and expertise. As an intelligence officer, I have published many peer review articles, a book, and other product over the past 20 years. And I've also served as the pre-publication review officer for the National Intelligence University for the past 3 years. As a pre-publication review officer, I have reviewed hundreds of documents on an annual basis. I also assist faculty, staff, and students representing all 17 components of the intelligence community with the review process. And in fact, in your reading materials, you have a copy of my own 2017 law review article that calls for some reforms in this process. My key points. First, I would note that under Title 50, Section 3024, Sub I, the Director of National Intelligence is responsible for protecting intelligence sources and methods from unauthorized disclosure. Moreover, there is ample evidence that unauthorized disclosure, typically known as a leak, of classified information can do significant damage to national security. Two examples here. One involves Herbert Yardley's 1931 book about the government's code-breaking efforts. And then there's also Philip Aggie's post-Vietnam books that published the names and addresses and other personal information of over 2,000 intelligence officers who were serving abroad. Books like these can cause considerable damage and irreparable injury to U.S. interests. Now, a series of federal cases, some public commentary suggests there are problems in the process. And you can see my own law review article for some of my own ideas and concerns. So, how does this process work? First, you should note that the president controls the classification of information under Executive Order 13526, and he likely does so under his constitutional authorities as the commander-in-chief. Second, Congress has passed numerous criminal statutes that are relevant to espionage and the unauthorized disclosure of classified information. Third, you should note that all government employees with access to classified information are obligated to sign a non-disclosure agreement as a condition of employment. Typically, this is something which is covered during initial employment processing. Employees also go through periodic security updates, and this is also covered when people conclude their employment. But this non-disclosure agreement establishes a fiduciary obligation to protect sources and methods and to submit personal product for pre-publication review. This is also a lifetime obligation. Fourth, you might note that the federal courts, including the US Supreme Court, have repeatedly found this to be a lawful restriction on an employee's First Amendment rights and have upheld the government's right to civil damages against persons who fail to submit material for pre-publication review. Two leading cases in this area are Marchetti and SNEP. I would note that pre-publication review is a little different from FOIA. With FOIA, there is a statute that dictates how things are covered. With pre-pub review, it's largely been covered by state case law, which means that there's not necessarily the clarity on some issues that you might have with a statute. As an employee, this process is quite straightforward. I must prepare my draft product for pre-publication review and then submit that product through my supervisor to the agency pre-publication review office. At the Defense Intelligence Agency, where I'm actually employed, this is currently a 3-person team, and the team handles about 600 cases on an annual basis. It's a little down in the last year because of COVID, but 600 is probably an average that goes back over 20 years. In some cases, a pre-publication review officer can review the document and approve its prompt release. But in other cases, the reviewer cannot approve that release without referring the document to a subject matter expert, either within that agency or in the interagency. In other words, as a review officer, there are some nuances that I may not be familiar with, and I've got to consult with an expert to find out what is actually classified or classifiable in a particular paper. And while the review can often get completed within days or weeks, the process can be prolonged if the product is lengthy, relates to sensitive activities, lacks footnotes or other source citations, or requires interagency review. In fact, I've seen some employee products that have required review by multiple agencies and have required anywhere from 6 months to a year and a half. Generally, the pre-publication review staff works on documents on a first in, first out basis. Some agencies have a larger staff, so they're able to organize a little differently. But generally, the pre-pub office is mindful of any kind of important deadlines. So as an example, when I submitted my speaker notes for today, I highlighted the fact that it was scheduled for a presentation on March 8th. In a like manner, if I'm trying to publish a book or an article, I might highlight that to the staff. And in many cases, they can work to achieve that, particularly if it's not a sensitive topic or it doesn't require interagency review. But in any case, an employee can do himself a world of good if he submits his product early, qualifies certain statements, and provides ample sourcing for where he got information. The DIA, like a lot of other agencies, maintains a very good tracking system for all pre-publication review actions. An incoming action is logged, a record file is established, and the documents are initially reviewed. A file is annotated if that referral is made to a subject matter expert, either in the agency or elsewhere in government. And then the file is also annotated with responses come back from the referral. And of course, this is important for the pre-publication review staff. I mean, I don't think anybody wants to be responsible for an inadvertent disclosure, and the pre-pub staff very carefully documents its work. But when the final review comes back, an email is sent to that author that either provides the clearance or specifies any language that must be amended. And in most cases, what the pre-pub review officer will do is actually suggest language that might be acceptable. In other words, we make an effort to help the author get to yes, so to speak. As you might expect, these conversation exchanges with a current employee typically occur over a classified email system. In other words, on the classified system, we can typically explain to somebody what a particular problem is. But in the case of a former employee who doesn't have access to classified systems, it's a little bit more difficult, and that author might get a little less information about some of the background. I can assure you, however, that pre-publication review officers make every effort to redact with a scalpel and not a chainsaw. While authors have First Amendment rights, the government can limit publication for two general reasons. One is that product may contain information which is classified or classifiable. And then second, a supervisor can limit the publication for a current employee if it will impair the author's duty performance, interfere with the agency functions, or have an adverse on U.S. foreign relations. And that's based on a decision of the U.S. Supreme Court in Pickering versus the Board of Education. In practice, though, most redactions occur because information is classified as opposed to the second standard. Finally, if an employee goes through the process and he thinks he's been wronged, that person can generally seek redress either through an administrative official or file a complaint in federal district court. I would also mention here that this administrative appeal process is rather uncommon. In the last 23 years at the DIA, I think there have been a total of 10 that have gone through an administrative review. In most cases, these get resolved simply because the reviewing official and the authors sit down, they discuss what the concerns are, and let's say we're able to figure out how to get to yes. In some cases, we deal with employees, former employees, who they're just not understanding, why their product had a problem, because obviously I did a good job of writing it. Believe me, I've been there. I've experienced that feeling myself. But in any case, an employee who fails to comply with obligations is liable to a range of sanctions. If you're a current employee, you can be disciplined to include loss of clearance, reprimands, monetary fines, or suspensions for failure to comply with the process. Former employees, a little different, of course, but they are subject to criminal and civil liability. But like I said, generally speaking, it's a process that I've been working with for the last 20 years. Pre-publication, I think, does a good job of trying to balance employee rights to include not just the right to speak, but also in a timely manner with legitimate national security concerns. The important point in the process, though, is the author has to front load it, doing good quality work, timely submissions, good sourcing. And then, like I said, generally there is a dialogue that occurs within the review process. Are there some mistakes? Can you find a reviewer who is a little heavy-handed? Yes, these things happen. But generally speaking, the system has its own way of working itself out. Thank you.
Thanks, Christopher. Before we move on, I just have two quick questions just of clarification. The first one is something I might have missed. I apologize, which is who is covered by this? And the second question is, when you say classified, does that refer to all levels of classification or just certain levels?
This process applies to all persons who hold a clearance and have signed a non-disclosure agreement. And it can apply to both current employees as well as past employees. And then, I'm sorry, what was the second question?
Yeah, the second question is, does it refer, when you say classified information, is that any level of classification?
Yes, it is. And it starts with something which is confidential through secret and top secret. There is a little bit of an issue here because sometimes it's possible to bring together unclassified information, and as a compilation, it becomes classifiable. But even
Okay.
yeah, it's
No, thanks. I just wanted to clear those two things up because I was wondering, and others might have been too. But thank you so much for your presentation. It's very helpful. So now we'll move on to Mary Rose. Hello, welcome.
Hello, Abner. Hello, panelists. Hello, everyone. It is such a thrill to be back at Fordham, even if just virtually. I started my teaching career at Fordham, and I'll always be grateful. So today I thought I would offer a bird's eye view of the First Amendment and national security, just so we can all place this body of law in context. One way I like to view these issues is to look at how the court has treated government insiders, i.e. government employees and contractors, current or former, with government outsiders, typically the press, but any third party who did not obtain classified information as part of their job duties. And we've seen two radically different bodies of law develop, although there is some pressure on both sides that may bring them closer together. And so that's what I want to explore with you in my very brief time. Okay, so what we see in this dichotomy is a treatment of the government insiders as people who are in a position of trust. And if they breach the trust and they reveal classified information without authorization, their First Amendment rights are pretty much non-existent. Versus the government outsiders, where we see the court embracing this idea of a game of leaks. If you can get the information, you can publish it. Now, this is a radical oversimplification of these two regimes, but I think it's helpful to frame it that way. So with respect to government outsiders, and again, the press is the typical example, but any third party, one of the most famous cases, I'm sure you all know about the Pentagon Papers case from 1971. This is a prior restraint case where the court rejected the government's attempt to restrain the publication of the Pentagon Papers, which was a detailed history of the U.S. involvement in the Vietnam War, largely historical. And in this decision, the justices note there was no statutory authority for a prior restraint. Well, I should say there were lots of different opinions in a very short per curiam, but if you look at the majority of the justices and look at their opinions together, they decide there's no statutory authority for a prior restraint. They emphasize that prior restraints are presumptively unconstitutional and require the government to meet an extraordinarily high standard of showing grave and irreparable harm. Since the Pentagon Papers case, we've seen only one other lower court decision where the US government has sought a prior restraint against a third party to restrain the publication of sensitive national security information. And likely the government doesn't do this anymore because of futility. The difficulty, it's like whack-a-mole, if you try to restrain the publication, will just come up somewhere else. Now, one issue the Pentagon Papers case left open was whether criminal prosecutions after publication would still be possible. And again, if you add up the votes, you'll see that there was a majority of the justices definitely left open this possibility. And since 1971, the government has frequently threatened to prosecute the press for publishing national security information, although it really hasn't happened, except recently we have the Julian Assange case. So one thing that we really don't have a resolution on is whether there is a meaningful difference between prior restraints and criminal punishment. I have argued that the threat of criminal punishment is pretty severe and may chill speech and is a really big deal as well. But prior restraints, there's a tradition in the US that prior restraints are anathema to the First Amendment because the speech never gets uttered at all. And so in that way, there could be a meaningful difference. The government has prosecuted 2 third parties after the fact, or I should say, well, there were 3. So within the APEC prosecution that was brought in the Eastern District of Virginia, the government prosecuted 2 lobbyists. So they were third parties, although they weren't members of the media. This prosecution was dropped after the district court judge issued an opinion requiring the government to show bad faith intent, which the government, I suspect, felt it could not do. Currently, we see the prosecution of Julian Assange. The government is desperate to show that Julian Assange is not a journalist. And in the press releases, the government has focused on the allegations in the indictment on Assange's alleged assistance to Chelsea Manning to attempt to hack into government systems. But this indictment also includes some Espionage Act charges. What will happen with this prosecution is anyone's guess. Apparently, the Biden administration is still pressing the extradition of Julian Assange, and so time will tell whether this goes forward. If the case goes forward, there are some issues that courts will have to resolve. One of them is, what role does the case called Bartnicki versus Vopper have on a case when you have a third party who is not involved at all in the obtaining of the information? Does that case have any relevance whatsoever when a third party publishes information? In Bartnicki, a tape of an intercepted conversation just showed up in the mailbox. Wasn't clear who taped it, and the defendants had no role in the underlying wiretapping. One way of distinguishing this case is if there is any involvement whatsoever, that the parties will not get the protections of the Bartnicki case. But here I want to highlight something. This is sort of the theme of my comments, that in this decision, the court held not only that the disclosure was a matter of high public concern, but this was not a national security case. And so some commentators have said that all bets are off, that Bartnicki may not apply at all in the national security context. So although Bartnicki is a very speech protective First Amendment case, litigants who rely on that case may find that courts distinguish it and determine that because it wasn't a national security case, it doesn't apply. This is because courts often routinely defer to the executive branch when national security is involved. We see this in the FOIA context, as Christopher mentioned FOIA, so worthwhile to bring it there. We see this in some other, I'm sure if there are any students here in your con law survey class, you saw deference to the executive branch. In the First Amendment context, we have the Holder versus humanitarian aid case, where the court did not apply its usual strict scrutiny and instead deferred to the government that material support to terrorism include human rights lawyers advising terrorist groups about non-terrorism issues, accepting the government's theory that funds are fungible. Okay, so to summarize, government outsiders, although we have this Pentagon Papers case that says prior restraints are really bad, it's not quite clear what's going to happen with subsequent criminal punishment. Now, the landscape with government insiders is pretty poor. And so Ramna, I'm sure, will tell us about her efforts to challenge the current state of the law. But I'm going to just summarize what I see right now. First of all, I think Christopher mentioned there are administrative sanctions available if government insiders reveal information. They can be stripped of their security clearances. Never mind all the cultural shaming and all of that goes along for government employees who reveal information without authorization. Many of you may have heard that leak prosecutions have dramatically increased in the last several years, starting under President Bush through the Obama administration and then the Trump administration. The First Amendment rights for leakers, we haven't seen a First Amendment case yet, but lower courts have not recognized robust First Amendment rights for leakers. There is no protection whatsoever for a leaker, even if what they reveal is important for the public's interest. Now, this could change. Maybe one day we'll see the court take a case where a leaker revealed information that was vital to the public interest, that revealed government wrongdoing, that the public had a strong interest in knowing. But as of now, we don't see the lower courts embracing that. Now, the real rub in this pre-publication regime is this awful case, the SNEP case. Now, if I could pick one Supreme Court case that's really awful, you know, there are a few candidates, but I'm going to go with SNEP as being one of the worst. So SNEP decided that the government could impose a constructive trust on the profits of a book that was published without going through the pre-publication review process. This decision was issued without oral argument. It was remarkable. Although it was decided in 1980, the court did not mention the Pentagon Papers case, did not mention prior restraint except in a brief footnote, and did not mention its jurisprudence on employee speech rights that started in the Pickering case. It was bizarre. Now, maybe not so bizarre if you accept the premise of my comments here, which is that the court always goes bananas when national security is involved. They just don't think rationally. So you know, what we see in the SNEP case is the court embracing this idea, which it has rejected in other contexts, that essentially national security employees have forfeited their First Amendment rights. Now, this is not consistent with the rest of the court's First Amendment jurisprudence relating to government employees. So in the Pickering case from 1968, the court decided that that it was important for a court to balance the interests of an employee as a citizen in commenting on matters of public concern and the interest of the government as an employer in promoting the efficiency of the public services it performs through its employees. Since 1968, the court has watered down these protections, but they are still present. One cautionary tale for those who might say that, well, Pickering will solve our problems if the court only embraced it. We do see the court mentioning, like in the most recent decision, Lane v. Franks, that they say specifically that the government had not shown that the testimony of the employee in that case was false or erroneous, or that he had unnecessarily disclosed sensitive, confidential, or privileged information. So it's possible that if the court actually tried to reconcile its decisions in the Pentagon Papers case or in the Pickering line of cases, it would distinguish them away. One, that these employees are in a position of trust, and so they're differently situated from the government outsiders. Secondly, that the Pickering line of cases are just not applicable when you're talking about sensitive national security information. I'm out of time, so I'll just say one thing I also want to mention that really colors the analysis here is the fact that these employees all sign these non-disclosure agreements. And when I teach this issue, my students are always like, but they signed the contract. That should be the end of the story. And I want to say that that cannot possibly be right. Now, there is a doctrine called the unconstitutional conditions doctrine. It's a mess. It's not clear what the answer would be, but certainly there's possibility that because government employees have no ability to negotiate this, and also it prevents them from sharing important information as a matter of public interest, that these contracts are not viable in light of the First Amendment. I also want to highlight that some courts have started to look beyond non-disclosure agreements in other contexts. And I'll just bring to your attention the Overby case out of the Fourth Circuit, where the court held that a non-disclosure agreement that was part of a settlement case in a police brutality case violated the First Amendment because it deprived the public of important information. So there might be some traction there as well. So anyway, that's my bird's eye view. I look forward to Q&A. Thank you.
Thank you. Thank you so much, Mary Rose. One question I'm going to want to ask you when we get to the colloquy is to press you on SNAP a little bit and to play devil's advocate about it. But before we do that, we have Ramya now for her 10 minutes. Hello.
Hi, everyone. My name is Ramya Krishnan. I'm a staff attorney at the Knight Institute. Thank you so much for having me on this panel. So my brief time today, I thought I would touch on a few things. First, the pathologies, as at least I see them, with the current pre-publication review system. I then want to describe the lawsuit that we at the Knight Institute have brought with the ACLU challenging the constitutionality of that system. And then I finally want to touch on some proposed reforms to the system. So starting with the current system and what it looks like. And I think it's important to note here that there have been many voices across the political spectrum that have now sort of remarked upon the fact that the current system of pre-publication review is really broken. So the system was initially introduced in the years following World War II, and when it was established, it was initially modest in scope and in purpose. It was really established to prevent inadvertent disclosures of classified information. But in recent decades, the system has become increasingly expansive and dysfunctional. So I want to touch on some of the problems. So the first is that many agencies impose pre-publication review obligations on former employees without regard to whether the employees ever had access to sensitive information and without regard to how long ago those employees left government service. And here, I think, our read of the system differs slightly from Christopher's. I think Christopher has said that in general, pre-publication review obligations only apply to former employees who once had security clearance. But based on agency policies that we have received in response to FOIA lawsuits, what we've seen is that actually the majority of agencies don't cabin pre-publication review obligations in that way. They are generally expressed to apply to all current and former employees. So second, what we've seen is that submission requirements and review standards are vague, they're confusing oftentimes, and they're overbroad. Review frequently takes weeks and even months. In some cases, it can take years. For example, one document released to us by the CIA projected that reviews of book-length manuscripts will now take over a year. And finally, when agencies do issue decisions, they often appear arbitrary or motivated by political concerns rather than national security. So the fundamental brokenness of this system, in our view, exacts a really like an immeasurable cost on public discourse. Former intelligence agency employees have unique insights into the operations and policies of the agencies for which they worked. And the current system frequently works to deprive the public of these insights, making it more difficult to understand government policy and to hold government officials accountable. So in 2019, the Knight Institute and the ACLU filed a lawsuit challenging the constitutionality of several agencies' pre-publication review regimes. And that's the reason I say several agencies' pre-publication review regimes is that there is no single executive-wide branch policy on pre-publication review. Agencies have basically been left to their own devices, and they've developed this, really complex patchwork of non-disclosure agreements, agency policies and regulations to govern the pre-publication review process. So we brought our lawsuit on behalf of 5 former intelligence agency employees and military personnel. And our primary claim is that the agency's pre-publication review regimes impose a prior restraint on the speech of former government employees in violation of the First Amendment. And it's perhaps surprising to no one, based on Mary Rosa's description of SNEP, that the main obstacle to our claim is SNEP. The government argues that SNEP effectively holds that the pre-publication review systems are per se constitutional. And we think that's wrong for several reasons. So first, in SNEP, the Supreme Court was focused almost entirely on the question of remedy. That is, this question of whether the CIA could lawfully impose a constructive trust on a former CIA agent who had published a book without even submitting it to review. As Marie Rose mentioned, they addressed the First Amendment claim in a conclusory footnote that didn't mention Pentagon Papers, and that it was sort of difficult to reconcile with traditional prior restraint analysis. But what the sort of posture of the case meant is that the court didn't have occasion to consider the arguments that we make in our lawsuit. So while it held that the concept of pre-publication review was compatible with the First Amendment, it didn't address the constitutional bounds of the government's authority to require former employees to submit to review. For example, it didn't consider what materials an agency might constitutionally require former employees to submit for review, what standards an agency might constitutionally use in conducting its review, or what procedural safeguards were required in such a process. Second, the legal landscape has shifted in important ways since SNEP was decided. So most significantly, you have a Supreme Court case called NTU, which has since clarified that prior restraints imposed on public employees are subject to essentially the same scrutiny as prior restraints imposed in other contexts. And then finally, the factual landscape of the pre-publication review system itself has changed pretty dramatically. So SNEP was decided in 1980. In the decades since SNEP, the pre-publication review system has expanded on pretty much every axis. So you have more agencies imposing pre-publication review obligations. When SNEP was decided, only the CIA and NSA imposed lifetime pre-publication review obligations. Now, as Christopher mentioned, all 17 intelligence agencies impose lifetime pre-publication review obligations. Agencies are imposing pre-publication review obligations on more categories of people. So initially, agencies were imposing obligations only on people who had access to what's called sensitive compartmented information or classified information about intelligence sources and methods. Now, as I mentioned before, they're not cabined in that way. And there's much more classified information. So what this means is there is more material that is subject to review, and agencies are taking much longer to complete their reviews. So we filed our lawsuit in a district court in Maryland, and that district court found that our clients had standing, but it sided with the government on the merits based largely on the Supreme Court's decision in SNEP. We now have an appeal pending before the Fourth Circuit. That appeal is fully briefed and it's been scheduled for oral argument in May, and I'm happy to discuss our appeal later on. So finally, how do we think this system could be improved? So late last year, I, along with some colleagues at the Knight Institute, wrote a post on Just Security proposing that President Biden issue an executive order that reforms the pre-publication review system. And we think that this executive order should reform the system in three key ways. First, we think that it should narrow the scope of the system. And what I mean by this is that the executive order should shrink the universe of former employees who are subject to review obligations and limit the kinds of materials that are required to be submitted. Second, we think that the EO should establish new procedural safeguards, including narrow and definite criteria for review, clear deadlines for decision, explanations of the reasons for agency censorial decisions, and an effective appeals process. And finally, we think that the EO should require transparency in the pre-publication review process, including by requiring agencies to publish their policies, something they're not currently required to do now, and instituting an audit process. We think that these reforms strike a better balance between the government's legitimate national security interests in this space and the First Amendment interests of would-be authors, as well as the interests of the public. So I'll leave it there, but I'm happy to speak to any of what I've said later on.
Thank you so much, Ramya. The proposals for President Biden seem very sensible to me. But the first, I think I should start with a question that I think we need to get cleared up, right? Which is that I think there maybe is a little bit of a dispute between Christopher and Ramya about the scope of the employees who are covered. Christopher said it was only those with a clearance or who have held a clearance, and Ramya says it's broader. Christopher, what's your response to that?
Well, it depends upon what we're talking about. If we're talking about classified information, we're talking about people who hold clearances and have signed a non-disclosure agreement. That is largely the Marchetti SNEP line of decisions. On the other hand, Pickering deals with a sensitive position. I think the employee there was in a Board of Education job, and that person was seeking to criticize his current employer. But generally speaking, when we talk about Marchetti SNAP, we are talking about people who have access to classified information.
Right. So Ramya, do you have reason to believe that in terms of federal employees that it's broader than that?
Yes. So I think part of the problem is sort of what I alluded to before, which is that many agencies impose sort of overlapping pre-publication review obligations on former employees. So you have many different sources of the pre-publication review obligation. You have the non-disclosure agreements, which I agree with Christopher, are generally signed by employees as a condition of receiving access to classified information. But then you also have these agency policies which don't condition the obligation on access to classified information. And so it's difficult to reconcile those two things. But it's sort of notable that in our litigation, that the government hasn't really contested this idea that the agency policies of at least some of the defendants apply more broadly than people who have had access to classified information or who have a security clearance. But the other point I'll mention is that even if those obligations only apply to people who have security clearances, we're talking about over sort of 5 million people. Professors Jack Goldsmith and Una Hathaway wrote an amicus brief in our case, which drew a sort of conservative estimate of 1.5% of the US population being covered by pre-publication review obligations. So even if we count sort of according to that measure, we're talking about a very large number of people.
And Ramya, how much of your case or what you're pushing for as a matter of policy has to do with the problem of overclassification itself?
So I think that, you know, the problem of overclassification is certainly part of the sort of background to our case, but we don't challenge the classification system. So the balance of that is sort of beyond the scope of our case. We sort of take it as it is, but we do note that it is contributing or exaggerating some of the existing pathologies in the pre-publication review system.
Okay, let me let Mary Rose jump in if you had any questions or comments from the last half hour.
Oh, yeah. So I do think noting that there is a undisputed problem with classification or overclassification is important. I understand the Knight Institute has lots of battles to fight on this front, and you know, they can't always fight that one, but it is an important background. Also, just the sheer number of people who have access to classified information has dramatically increased. So you're just talking about so many employees and so much information that is important for the American public to know. And I guess that's the other thing I want to emphasize, that although there are, national security is important, we need to protect our national security. I don't think anyone here would dispute that. We also have to recognize that for a democracy, often information about national security is the most important information for the public to have. So there is a real tension here that we can't just excuse away because, oh, national security. The other thing on the classification I would mention is that my understanding with this, the way pre-publication review works is that, it will extend beyond just things that are actually classified, and things suddenly become classified or born classified, like during the review process, that is also very troubling. The idea in SNEP itself, this problematic opinion, recognizes that even information that isn't classified, perhaps that poses a danger to national security because, it creates they didn't use this word in this opinion, but mosaic, it creates contributes to a broader understanding of national security interests. So I would just say that the problems we have with the classified information system are definitely make it even, this whole regime even more problematic.
Christopher, do you have views from the inside, as it were, about whether you would support reforms to the classification system?
Well, I think there is some possibility of or some areas that the system can be reformed. I mean, we talk about a number of different issues. One, of course, is agency resourcing. The amount of resources that each agency puts against this problem varies significantly. In some small agencies, there may not even be one full-time person dedicated to full-time pre-pub review. It might be an additional duty. At the DIA, we have 3 people. Right now with COVID, some pre-publication review staffs are actually shut down because the individuals simply aren't able to come to work. Other agencies with larger responsibilities, and possibly the CIA might be an example, have a much larger staff that is able to dedicate themselves. But like I said, resources would be one line of approach. The vagueness issue that has been raised is a tough one. I mean, I've had people come to me and say, well, would this be a problem? Gee, I'm not sure. I need to see your product in writing before I can pass judgment on whether or not something is going to be reviewed. And there are some differences here between the agencies. In one agency, I might be able to write a cookbook. I'm a great Dutch oven cook. I'm going to write a cookbook. Does that cookbook require pre-publication review? Some places will say yes, some places will say no, particularly if my cookbook doesn't identify me as a government employee.
Christopher, if it's that cookbook from that classic Twilight Zone episode, people will know exactly what I'm talking about. Then it would definitely require pre-publication review. Ram, did you have any response to anything that you've been hearing so far?
Yeah, I mean, I would just say that I agree with everything that Mary Rose just said about the sort of importance of hearing from these former officials on matters relating to national security and foreign policy and war. I guess the other thing that I'd mention is just noting that so you have sort of like two problems in terms of the scope of the system's application. You have the problem of who does this system apply to, but then you also have the problem of what materials people required to submit, and this goes to Christopher's point. And right now, many of the agencies require former employees to submit virtually anything that touches not only on government service, but on government policy. So for example, if you had a CIA officer who had been employed for 1 month in the 1970s to analyze US foreign policy toward Vietnam, today they'd have to submit for review any pieces concerning the CIA's assessment of Russian interference in the 2016 election, or the NSA's bulk collection of Americans' call records, or even the TV show The Americans, because the submission obligation often isn't tied to whether your manuscript plausibly contains information that's classified information. And it's also not tied to whether your manuscript plausibly contains information that you obtained while you were actually in government. And so we see both of those things as problematic.
Thank you, Mary Rose. And then we'll have a couple of questions up on the board, and there might be others before we have to go. Mary Rose?
Yeah, sure. One thing I thought was worth highlighting is that the Knight Institute's challenge includes not just a First Amendment challenge, but a due process challenge. And, I hope that they're successful with their First Amendment challenge. They'll probably have to go to the Supreme Court to be successful on that. And maybe they will or won't be up there. That's an interesting question we might maybe take up in Q&A. But the due process problem is very real here. And even if the courts accept that the federal government can require pre-publication review, the lack of enforceable timelines and meaningful appeal, those things could be get some ground. And I'll just again, to give us a broader view, in the NSA national security letter context, companies receiving these national security letters have fought against the gag orders that they have been provided. Required not to tell that they've received these information requests to reveal information about their customers, and they have not been super successful on the First Amendment front, but they have been more successful arguing about due process, and there were changes made to the system in response to those concerns. So I just thought it was worthwhile. It may not seem as sexy, to talk about due process, but it is very important. The time that the delay of getting this information out to the public is a real problem. The lack of meaningful appeal and standards is also as much troubling as the fact that we even have this whole system to begin with.
No, thanks on that. Let's just turn to, it is 10:38. I see we have hit till 10:45. I see. Let's start with if you all can see the questions in the Q&A panelists. The first question from Beth Shapiro: what was the situation with the Bolton book? Christopher, do you have any quick response to that?
That's not a book that I'm familiar with in terms of it going through the pre-publication review.
Okay.
The only thing I could say there is that if he was a White House official, that certainly would have gone through any pre-publication review in the White House itself.
Okay.
Not necessarily the interagency. And it may be that there are parts of that book that, should have been releasable, that the White House wasn't willing to let go of for political reasons. But like I said, I don't know.
And then the next question is an interesting question from Stephen Conte. Is there an interplay between First Amendment rights and whistleblower protections for government insiders employees? I'll open it up to the panel.
I think this is an largely unexplored area. What it should be, what the interaction should be. There are not robust whistleblower protections for national security employees, so I just want to highlight that. That's problem number one right now. So it's not actually the case that national security employees will find themselves in good shape if they go outside of the channels of going to an inspector general or perhaps to Congress. But if they go out into the public and publish or talk to the press, there actually is no protection for that kind of activity. I have argued in prior work there should be something, and this is what I was getting to in my comments about matters that are of strong public interest, I think should be protected, but that is not where we are right now. So, but I do think it's worthwhile to start thinking about how all of these regimes fit together, and I think it's not entirely clear how they do or will, I should say, down the road.
Do either of the other panelists want to comment on that question?
I would argue
No?
that it's important to remember that when we talk whistleblowers, we're talking about people who go through a protected process. And that's very different from the leaker who just goes to his favorite journalist and leaks information. I think this raises some interesting legal and ethical issues. I mean, it's one thing if you're Samuel Morrison and you're leaking for private gain, or you're Lawrence Franklin and you are leaking for what you see as or your own view of the government interest, versus Thomas Drake, who actually leaked or outed an illegal program. In other words, Drake probably had an ethical obligation to out something, even though that outing was illegal. Certain.
So where does that leave Snowden?
Well, that's a good question, and I'm not really sure, what his motivations were. I mean, there is one.
Well, does it matter? Does it matter the motivations, or does it matter our ex post assessment of whether or not he leaked an illegal program?
I think both are important. He tells a story about why he did what he did. I'm not sure that's the whole story. And then we have the second question about whether or not, or to what extent, the program was actually illegal.
Of course.
One of the things that's interesting to me, though, when we talk about Drake or Snowden, is that some of these people never try to go through a protected process. They go straight to their favorite.
I'm sure they felt they would.
Yeah.
They were probably concerned about what would happen if they tried that, right?
Well, as the story goes, yes.
I guess
I
Abner,
was wondering
if you didn't mind, Abner, whistleblowers also is a more narrow definition of who is a whistleblower as far as the content. So waste, fraud, abuse, illegality, those are the typical categories of a whistleblower. And I think in this context, it's much, much broader, the types of information that that these public employees, past and present, want to share. It's not necessarily, won't necessarily fall within those categories.
Can I just ask a quick question about SNAP? So this goes back to Mary Rose's. I'm going to take the third question on the board to some extent been answered earlier by Ramya when you listed the various potential due process problems. Now SNAP, you're allowed under the SNAP precedent, you publish the book and then you have to disgorge your profits or something, or have it constructively, right? It's not a prior restraint in the sense that they're shutting down the printing press, right? Ask that for all three of you, but Mary Rose in particular.
Oh, I'm sorry. I'm sorry. Well,
sorry. Yeah.
The opportunity, still there is an opportunity if the government wants to try to get a prior restraint. It still is possible. And that happened in the Bolton case. The government tried. The government waited until the book had already been shipped. So it was kind of a weird timing issue there. And so they clearly lost that case. I mean, maybe if they had brought it earlier, they would have had better luck. So I don't think SNAP in any way says the government can't seek a prior restraint.
Well, but it doesn't authorize a prior restraint. It authorizes a certain kind of monetary remedy, correct?
Well, I think that was it was the focus of the decision. But if you there's so much unhelpful language. I'm sorry, Ramya, for your case. In the for example, in a footnote, it says that he signed this agreement obligating him to submit any proposed publication for prior review, and basically endorses this regime. Although, but you're quite right. The focus of the opinion was not a prior restraint. That wasn't what the government was seeking in that case. They were seeking a constructive trust as a result of him not following the pre-publication review regime.
Let me just see if Ramya has any last words on this.
Yeah, I think that, so you're absolutely right. It wasn't a sort of Pentagon Papers case where the government was going in seeking an injunction against publication of SNAP's book. But the First Amendment argument made by SNAP was that the government should not be entitled to a declaration that he breached his contract because he said that contract was unenforceable as a prior restraint. And so that's the argument that, as Mary Rose mentions, the court rejected in a footnote. But the other thing I'll just mention about that footnote is it's very unclear what standard what standard of scrutiny the court is applying. There's some language that you might associate with strict scrutiny, like the government has a compelling interest in this system. There's some that's associated with, Pickering analysis. We think that like the best sort of reading of that footnote, despite the incoherent language, is that the framework they were trying to apply was Pickering, because the primary cite is to a case applying Pickering. But it's very difficult to sort of, understand in a coherent way.
I think if a student submitted this opinion in class, I'd give it a D.
Okay. Thank you for, there's a lot of still questions that I have that didn't get to, but fascinating discussion. Thank you to Christopher, Mary Rose, and Rami. And let me see if anyone from the journal wants to come back in at this point and say hi to everyone. Maybe, maybe not. All right. Well, anyway, thank you all. Thank you to the audience. And that concludes this panel.
Thank
Thank
you.
you, everyone. That was
Good
a lot
luck.
of fun.
Yeah. Bye.
Bye-bye.
Hi, I'm Sharif Farag, third-year Fordham law student and one of the senior notes and articles editors of the Fordham Intellectual Property Law Journal. I'd like to introduce Professor Olivier Sylvain, moderator of Hitting Back, Slap Suits, and Anti-Slap Statutes. Professor Sylvain is a professor of law at Fordham. He specializes in communications law and policy, including the public regulation of information flows. He's written on a variety of topics, one of them being liability for social networking sites under the Communications Decency Act. I hope you enjoy the panel.
Hello, everyone. Thanks for joining us. Thank you to Claire and the rest of the IPLJ for putting this program together. Such an impressive list of folks and topics. I do want to note that Claire is pretty impressive. She's also the president of the Fordham Media and Entertainment Law Society. She's got a lot of hats, doing a lot of work, and grateful for all the time she's put into this. I'm so pleased to be moderating this panel with great experts in the area. I will introduce them briefly each. You can see more complete biographical information in the materials, I believe. Let me just say a couple words about our topic, and then I'm going to turn to Laura, who will give us a history after I introduce everyone. So SLAP suits are as some of you may know, it stands for Strategic Lawsuits Against Public Participation. And they're generally filed for the purpose, the suits themselves are filed for the purpose of silencing critics using the burdens of litigation. Most states have some anti-SLAP laws meant to protect free speech and journalism and all kind of media. And it provides a quick mechanism for dismissal of lawsuits. But there is no anti-SLAP protection at the federal level, and there are some states that don't have this protection. Last November, New York substantially expanded protections for SLAP suits in furtherance of the protection of media and journalists. Now it doesn't just cover real estate developers who are suing environmentalists, for example. And some of you may have caught wind of the issues involving anti-SLAP suits if you saw John Oliver's program a year and a half or so ago. And for what it's worth, momentum for federal legislation seems to be growing. So I'm going to stop here, and I want to introduce our fabulous panel in the order they will speak at the outset. Laura Lee Prather is a partner at Haynes Boone. She is in the litigation practice group in the Austin office. There, she focuses her practice on First Amendment, anti-SLAP, intellectual property, and media and entertainment litigation and appeals. She has an extensive government relations experience. And most interestingly, for those of you who want to have a deep dive into this, co-authored a piece with Texas Tech law professor Rob Sherwin on related issues, specifically the Texas Citizens Participation Act. Next, Evan Mascagni is a policy director at Public Participation Project, based in New York. He is based in New York. He's a former attorney turned documentary filmmaker, which has to be one of the best bios anyone can have. He's at now Player Piano, where he's producing films and continues to be a First Amendment rights advocate. He continues to work on related issues involving California's anti-SLAPP work, and as we'll discuss here, New York's issues. And then Ken Sweezy, partner at Cohen, Debates, Abraham, and Shepard, based in New York. Ken is our transactional lawyer on the panel. He's counsels in the areas of copyright, corporate, digital media, entertainment, publishing, and other IP and commercial matters. He has a wide range of clients, some of whom are very well known, and he teaches and speaks widely on IP and digital media. This is a great panel. Thank you for joining us, folks. Laura, I think we'll start with you. Can you just set the stage for us, give us a brief history of anti-SLAPP laws in the US? And by the way, I'm sorry to interrupt my own question. I'm going to tell the audience that in the interest of opening conversation up, that each of our panelists will present some ideas, but we'll have engagement hopefully from other people as well. And we'll try to have time for Q&A at the end. So I interrupted myself. Laura, please, maybe some background.
Happy to do so, thank you. So as was mentioned, SLAPP suits, the SLAPP acronym stands for Strategic Lawsuit Against Public Participation. And that acronym was derived from research done by two professors in Denver, George Pring and Penelope Canaan. And it basically defines a specific form of judicial harassment where one uses the legal system to try to silence critics by the filing of a meritless claim. And the purpose of that claim is really just to shut them up. It's to shut them up or to bankrupt them, to inflict pain. It is really not for the purpose of obtaining a victory in court. They accomplish their goals just through this punishment of the speaker and also by deterring other people from acting or speaking in a similar fashion. And you see examples, sadly, just in everyday life. You see, the college student who gets sued for a Facebook post in which they've complained about a towing company. You see examples where the media gets sued for their investigative reporting, where they expose wrongdoing that's happening. And here in Texas, I've been involved both through litigation and through legislation, was involved with the passage of the Texas law and the continuing fight to maintain the Texas law. We had a woman who told an incredibly compelling story where she had put her brother in an assisted living facility. Her mother had passed away. Her brother was special needs, needed to be cared for 24 hours a day, puts her brother in an assisted living facility, and they're not properly caring for him. They're not giving him the medication that he needs. And so she starts to try to get that situation rectified, which doesn't happen. And so she ultimately files a complaint with the Texas Department of Health and Human Services. She writes a letter and posts it on the senior living website. And she writes a letter to the assisted living facility. For that, her brother was summarily kicked out of the home and she was sued. Now, this is a quintessential SLAPP suit because she is telling the truth. She's warning others. She's complaining to government officials. And yet nothing gets solved except that she gets sued. She has to cash in her 401k, hire a lawyer, and fight back in the court system from these meritless claims. And 3 days prior to the SLAPP hearing, the assisted living facility says, well, we'll drop our suit if you'll just take down your post and if you'll just withdraw your complaint. Now, the damage has already been done. She's already had to hire a lawyer, cash in her 401k plan, expend the resources to fight all of this in court. And she says no. And thankfully, because we have a strong SLAPP statute here in Texas, she was able to fight back and she was able to recoup her fees. But that is a classic example of what a SLAPP suit is. And Professor Pring and Professor Canan started to study this in the late 80s. And when they did that, they tracked the number of SLAPP suits that were being filed. And once that was done, then you started to see state legislatures act. And the first was Washington State in 1989. And they passed a very narrow SLAPP suit. It just applied to claims based on statements made to the government in the course of a governmental proceeding. It wasn't until 1993 when California paved the way and passed a broader anti-SLAPP piece of legislation that provided protection for written and oral statements made in an open place to the public or in public form concerning a matter of public interest. And the value of a broad-based SLAPP statute is tremendous. They typically have features that include an expedited dismissal process where the court in the first instance can evaluate whether or not the case has any merit. They stay the discovery while this anti-SLAPP motion is pending. So you're not having to fight on two fronts and expend unnecessary resources through the long discovery process that can happen. They allow for an immediate review through the interlocutory appeal process if the motion is denied. And they allow for recoupment of fees so that someone can be, the individual who is a SLAPP victim can be made whole. So those are kind of the typical features of a really strong SLAPP statute. That's what you saw in the California SLAPP statute. And for the next 2 decades, you saw more and more more and more legislatures adopting SLAPP statutes, but they all had varying degrees of protection. Around 2010, for the next decade, there were at least a dozen states. There was an onslaught of broad-based SLAPP statutes being passed, Texas being one of them, but there were so many others, and so many states that had SLAPP statutes expanding the scope of their SLAPP protections. I think Evan's going to go into this a little bit more, but right now we're at 33 states, plus the District of Columbia, the Territory of Guam, and even our neighbors to the north in Canada, Ontario and British Columbia have SLAPP protections. So I'll hand it over to Evan, who I think is going to talk a little bit more about
Can I ask you one question, Laura?
Sure.
So over the course of time, you know, the various concerns about right to a jury trial, whether it arises in arbitration context with you know, or in this anti-SLAPP context. I am a First Amendment, you know, supporter, and I feel like, you know, anti-SLAPP laws serve a really good public purpose. But I'd like you to kind of, since you've been in the thick of this, I'm curious, you know, to have you faced that, you know, challenge either in Texas or not so much from a judge, but in the policy arena, the challenge of jury trial right.
Well, I mean, certainly we've had some spirited discussions about that. Some SLAPP statutes have been declared unconstitutional if they've had a higher burden. In Washington, that was one of the problems, and they're actually coming back at it. We'll talk about it a little later in today's discussion from a different standpoint. But summary disposition of cases involving, you know, whether it's summary judgment, whether it's a motion to dismiss, et cetera, are not unconstitutional. There is, you know, there are certain parameters within which the legislative language must fall. And for instance, the vast majority of right to a jury trial complaints that have been lodged against anti-SLAPP statutes, unless they've had a clear and convincing standard in them, like Washington had, they also had a punitive damages provision in it, have been upheld as constitutional.
Laura, I also want to ask a question also as a matter of context. So why in 2010 just around 2010, in your very helpful account, did you see states pushing for more expanded protection Why did it take 20 years?
I think it coincided with the just the sort of uptick of the internet and the fact that the internet became pervasive everywhere. Everyone became a publisher, and you started to see more and more suits getting filed against everyday citizens for statements that were made over the internet. And then you had social media being able to shed more light on these meritless lawsuits being filed.
Thank you. Evan.
Yeah, I'll kind of echo.
We've got a great historical background. So where are things now?
Yeah, I'm going to put my perspective in a little context too. So when I went to law school over 10 years ago, I went to law school in DC, and never once did I read anything about an anti-SLAPP motion or an anti-SLAPP law. Usually, I think if we were in person, I'd probably ask all the law students here how many have seen a mention of an anti-SLAPP law or a SLAPP in one of their legal textbooks. And it wasn't until I moved to California and I was studying for the bar exam, and I was studying the California Civil Procedure section, and I learned of this anti-SLAPP motion. And I was like, whoa, this is a really cool, innovative tool for people who have been hit with frivolous lawsuits that I'd never heard of before. And then, so after I took the bar and passed, it just so happened that the California Anti-SLAPP Project, one of the leading law firms fighting SLAPPs, was hiring. And so I took a job with them. And when I first started, I was doing intake. And this is, I was getting to where your last question, that was around 2009, 2010. And I remember most of the intake we would get were folks who were organizing or protesting, and would be tenants who were organizing and distributing flyers, those type of traditional SLAPPs against protest speech. And then over, the past decade, I've been working on this issue. It's really evolved into the online speech arena for the mentions that Laura already talked about. But yeah, so now I've watched also additional states enact these anti-SLAPP laws. Like Laura said, we're at over 30. And I think the most important thing to talk about is that these state anti-SLAPP statutes really vary in strength and breadth, right? And when I say that, New York is a great example that I think we'll talk about a little later, but it used to protect only petition activity, right? And now it's been expanded to protect speech and petition activity. There's states like Arizona, for example, that still only protect petition activity, but then you go to California and it protects a broad range of speech and petition activity on public issues. So the states vary in strength and breadth, which is ultimately why I do what I do, which is advocate for a federal anti-SLAPP law, right? Because oftentimes we see forum shopping where a plaintiff will file a SLAPP in a jurisdiction that's weak. I'll use Kentucky, for example, where I'm from. So they'll file, especially with internet speech, try and find a way to file that lawsuit in a state where there's no anti-SLAPP protections. And then also, the courts are split whether or not these statutes apply in federal court, right? Most, in California, for example, they've agreed that the California anti-SLAPP statute does not apply to federal claims in federal court, but then the circuits are split on whether or not these state anti-SLAPP statutes apply in federal court on diversity questions. So yeah, we're at, the trend is moving in the right direction, I think. Laura is going to speak later to the Uniform Law Commission, which I think is only going to help us get to all 50 states sooner rather than later having some form of anti-SLAPP protections.
So Evan, before we get to Ken, who will talk more about some complications and challenges and the New York law, which I hope we'll all engage. I'm curious to hear you say a bit more about the current laws, if you don't mind. So Ken was asking Laura about right to jury trial, the kind of countervailing public policy interests. So many different states have different ways of doing it. Is there a way to account for why different states come up with the approaches that they have? Say California's is especially protective. New York seems to be pretty protective, but others aren't. Do you have a sense for, you know this area very well, so I figure you've given some thought to this. I wonder if you have a way of explaining why the states are as various as they are.
Yeah, I wish I could say it was as simple as like a blue state or a red state issue, but I think fortunately it's not. And it's why I enjoy working on this issue. It brings together strange bedfellows from, all sorts of areas that, understand the importance of protecting the First Amendment and free speech and petition activity. To be honest, I think it can boil down to the strength of plaintiffs' attorneys and trial lawyers in a particular state, right? I mean, just as a matter of principle, I don't think any plaintiff's attorney or trial lawyer association is going to support a motion in their state, an additional tool for a defendant to get a slap tossed out before they get to discovery or get to trial. So that's probably what it's boiled down to in my personal experience is just navigating particular interest groups in different states. And it's not like they control, you know, the Dems in some state and Republicans in others. In Kentucky, I'm dealing with it right now. In Pennsylvania, we're dealing with it. So yeah, I think it's just different interests at different states, in different states and different stakes. But I don't know, Laura might have, or Ken might have something to add to that.
I'll tell you, I think Evan's spot on with regard to the fact that special interest groups certainly have significant sway in some states, but it also, I think, depends on the strength of the sponsor, the bill sponsor. And so we've all seen, you know, certain sponsors will force negotiations between the interested parties, and others just will do as they're told by special interest groups. And so if you have a strong sponsor with your bill, that makes all the difference in the world. And then if you can build a broad-based coalitions of groups on both sides of the aisle, I mean, honestly, this is something that helps the little guy, which is something that typically trial lawyers should like. It's an access to justice issue. It enables people to be able to fight a meritless lawsuit that wouldn't otherwise be able to obtain counsel. That too is something that should resonate with the plaintiff's bar. It's also a tort reform issue. It ferrets out those meritless lawsuits that are clogging up our judicial system. So in that sense, it appeals to those groups. It appeals to business groups because they get sued Better Business Bureau gets sued for their reliability reports and things like that. So you can build a broad-based coalition to support these efforts, but you need to kind of have a strong sponsor and a strong broad-based coalition going into these efforts. And that, I think, is where you see the broader protections exist in certain states as opposed to others.
I want to get to Ken, but I want to push a little bit more on this, and not because I agree with this position, but just to flesh this out some more. I think, Laura, you were talking about the clear and convincing standard that's a pretty high standard to have to meet. And many different states have different standards. So why is that? Why do they have, so you were talking about, I mean, that because you do a lot of the government work, Laura, I know this is the way to think about this, as with Evan, is a kind of mobilizing groups to do the right thing. But ultimately the policy choice, irrespective of the interests, are settled on, right? So what is maybe one way to ask this is, what is the measurable impact of having a substantial basis in law standard versus a clear and convincing standard versus some other standard? Maybe Evan or
Yeah, I mean, I can start. I think you can look back at California, for example, as one of the first strongest early enactors of anti-SLAPP laws, and they use this probability of prevailing language, right? And I think you look at a state like Pennsylvania, for example, where I testified this issue, they don't like that because what California did there was basically, it was the California Supreme Court interpreted what probability of prevailing meant, right? And they did so in a way that made the statute constitutional, right? So when you look at some more red states, for example, they don't want the courts to have to make that interpretation, right? So they want to, in the statute itself, put the plain language for what you mean, right? And we're dealing with this a lot. And so, you know, a lot of the new proposed language is sort of based on how the California Supreme Court interpreted probability of prevailing, right? Which is no genuine issue to material fact, and some additional language related to that. So I think it's, it really boils down to whether or not the state you know, in California, using probability prevailing wasn't an issue, but in another state, they might think, hey, we don't know how the courts are going to interpret this. So that's how we've seen sort of an evolution of how the language has changed. And Laura can chime in. The Uniform Law Commission basically looked at that from across the country and came up with their own language that I think they held would, you know, be upheld by courts as constitutional. We wouldn't run into any of these Minnesota or Washington state issues.
And what they did, that's exactly right. They looked at, they tried to figure out how to both make the law most likely to apply in federal court, where it would not conflict with existing federal rules and would be upheld as constitutional. And that's kind of how they derived the standards with regard to what was laid out in the uniform law.
And these laws don't apply extraterritorially, right? So no, they don't.
But don't you think some states picked, standards that allowed them to say they had anti-SLAPP, but not really give the protections that a robust anti-SLAPP law would give? Or did that issue didn't come up? That was how I saw it. Some states were just looking to say we have anti-SLAPP, but don't really give the defendants a full robust protection of a broad-based law.
So who are so what are the weakest states? Which states have some of the weakest laws here?
I mean, I think New York is a great example, and since we're here, it might be of interest, right? New York had a notoriously weak anti-SLAPP statute, right? It only and to answer Ken's question, I think it's more about the activity that's covered by the statute, right? And so in New York, it only protected, it didn't matter what the standard was that the plaintiff had to overcome, but more so what was actually protected, like who could invoke an anti-SLAPP motion. And in New York and in Arizona, for example, and New Mexico previously, it was just a very narrow form of petition activity, right? So let's just say an online review, for example, in New York, prior to the strengthening of the statute, that would not have been covered by an anti-SLAPP statute, right? So anything that involves free speech on a matter of public interest and not petition activity wasn't covered, right? And so I think now states, a lot of these statutes in there, when they were originally enacted, were sort of reactive, right? There was some case that got a lot of attention and they said, oh, wow, we need to create a mechanism where this doesn't happen again, right? And that happened in Pennsylvania, for example, where they would just cover a very specific class, a very specific type of cause of action. And then you see as time goes on that it's like, oh, wait, we actually looked at this a little too narrow. We should expand this. And I think New York's a great example. We now have what I think is a great anti-SLAPP law. But I'll let Laura Ken chime in if they want to add some more.
And when you say to petition, it's petition the government, right, Evan, or is it some other activity?
Yeah, sorry, exactly, petition the government. And even in certain states, there's been debates over what that actually means, if it's like a quasi-administrative hearing compared to, so there's even debate, there's very nuanced debates that are happening. And I think that's why the Uniform Law Commission has done such a good job at looking at states like California that have been dealing with these issues and these language issues for over 20 years and coming up with some of the best language that won't run into any of these constitutional concerns that were mentioned earlier.
So Ken, let's turn to you finally. Thank you, Evan and Laura, for that great setup. You can talk about some current challenges in anti-SLAPP litigation.
Yeah, I'm going to stick to the home state of New York here. So as Evan said, the old law was so narrow and so toothless as to be almost non-existent. People didn't really seriously think that New York had, an anti-SLAPP law in the way that we think of it in California. And so really the state went from 0 to 60, I think, when they, enacted the new law in 2020. It has a broad application across constitutional exercise of speech, which puts it on a par in terms of activity. It uses this substantial basis in law standard, which I think when we get to it in terms of challenges is going to have to get fleshed out, but it's potentially, depending how the courts go, amenable to a broad standard. It's got the stay in discovery, which I think is really critical to having an effective anti-SLAPP law. And the penalties are there, which in the old law, penalties were so discretionary as to be sort of non-existent. So I think that the overall New York setup is good and is going to serve the media here well. Not quite sure why, with such a media intense state, we were so late to the game, but then that may come back to Laura's, thoughts about, well, who's really the, putting this forward and able to get a discussion going. And obviously, Albany is a land of mystery, so we don't know what happens there or why. But it's great that they got their act together finally and put something strong on the books. In terms of challenges, some of the things I was looking at are the issue of retroactivity. We've sort of talked about it, I think, a little bit out there, but should this new anti-SLAPP statute, including not only its procedural points, but also its substantive points, should it apply retroactively? I think that early indicators are the end of the year. There was finally a decision in the Sarah Palin against New York Times case, and that one went in. That was a federal case in the Southern District, but it went in favor of taking a retroactive approach. I think that Judge Rakoff kind of did a nuanced decision saying, well, there already was a standard of malice in public figures, so we're going to apply retroactivity here. I think it's going to be an open question for a few more years. Eventually, retroactivity is not going to be an issue for us because we're going to just age out of it. There won't be retroactive cases after a while because the new cases brought after the laws in effect are by definition not going to be retroactive.
Ken, can I stop you just for a quick sec? Can you just flesh out what you mean by retroactive?
Sure. Should the anti-SLAPP protections, should the rights laid out, the early motion, the stay on discovery, the potential penalties of attorney's fees, should those apply to a case that was brought before the anti-SLAPP law was in effect, the new law? There was an old law, and you could try to piggyback onto the old law, but I don't think it really is a huge sea change. So should a plaintiff be subjected to this new set of rules in an older case? And all we can say is right now, there's the cases that are starting to be ruled on are finding that because the New York statute is considered quote unquote remedial in nature, so it's intended to correct a public issue of great import, and it was to be put into effect immediately, that the courts have held so far. I mean, there'll be a definitive decision by the Court of Appeals at some point, but right now it looks like retroactive effect, in meaning that ongoing cases that were brought before the statute's effective date are going to be covered by the statute. Does that get at your thought?
Yeah, great.
Then the next area that I think is interesting is it's a federal case. It's a recent case in New York, and they're looking at the sort of issue of, what are the contours of protected speech? And now I'm trying to find this case from my bunch of notes here. But anyways, it was brought by a group that was bringing their action under the here we go. National Coalition on Black Civic Participation against robocalling, discouraging voting activity. And the defendants came back with anti-SLAPP, and although this is in the Southern District again, and here you've got a question of what is covered speech, and what can fall outside the scope of speech, and it's sort of in the same category. We know that there are limits to free speech in terms of fighting words, and certainly the Civil Rights Act, the federal acts tell us that there are limits to what falls in the category of protected speech. And in this case, the court found in Southern District that the speech involved by the defendants was outside the contours of protected First Amendment speech, and so it wasn't amenable to the anti-SLAPP protections, and the speech was robocalls giving false information to potential voters, telling them not to vote by mail because they would be subject to credit checks and harassment and generally full-blown, in my mind, really outrageous, outside the scope of normal political activity that anyone could possibly countenance. And so the court felt that because they were bringing that under the Voting Rights Act and the KKK Act, that they would not be subject to an anti-SLAPP defense. And I think it's a good decision, but it tells us that there's another area around contours of speech that are true threats or non-constitutionally protected speech presumably won't be covered by anti-SLAPP.
I want to ask you about this case, if you don't mind, Ken.
Sure.
Sorry to put you on the spot again.
No, I'll try. It's a super interesting case.
No, it's great. You're doing great. This is fantastic. I'm just mindful, it just struck me, the Supreme Court is entertaining, or has been entertaining, the question of First Amendment protection of robocalls, as you know, and with a court that has a very enlarged view, and Justice Kavanaugh has a very enlarged view of what counts as protected speech by companies. Is this the sort of decision that could come out differently in a couple of years, or not?
I think I was going back to, and my constitutional law notes are going to fail me, but I think, is there a case called Black? There was a cross-burning case that the Supreme Court ruled on in the early 2000s, and someone can help me out if they know the name of the case. But it started to, to me, set a standard of saying, well, there's speech that crosses the line. Anyone can say anything at any time, but there's going to be a limit to what we're going to call constitutionally protected speech. So I feel like this is not a robocall case. This is a suppression of voting rights case. And if the Voting Rights Act is to have meaning, it seems, at least logical to me. It's not much of an extension to say it would apply to robocalling. And if it does apply to robocalling, then that's not the kind of a defendant that's going to get the benefit of anti-SLAPP. Any kind of robocalling, it could come out differently, but because of the nature of these robocalls.
The reason I asked it is because a case I had in mind is Facebook versus Dugwid that the court heard last December on robocalls under FCC related statute. FCC implements a related statute, Telephone Consumer Protection Act or something like that. And it doesn't squarely visit the question of whether robocalls are constitutionally protected, whether they are sharing disinformation or not, which is kind of what you were talking about. But I don't know, with a court that has already been prepared to say that lying can be constitutionally protected, I don't know what to make of this. I hope they don't go that way, and I'm inclined to agree with you about this decision here. But that's why I was asking the question.
No, it's a great question. I guess I'm thinking of, in the narrow category, it's a robocall that's being the plaintiff saying it violated their federal right to vote. So if there is a way to violate it, the robocall shouldn't exempt you from that. If they didn't violate it with the falsehood and everything else they did, then maybe they're not under that. But so moving along, I guess the next area, is maybe Laura's going to think about that from the perspective of the uniform law. But the substantial basis test in New York, I don't think it's fully fleshed out. I haven't come across a really clear standard-setting case. So clearly the legislature in New York wanted to. Oh my God, I'm running long. Wanted to hit on something more than cognizable, more than the old-fashioned motion to dismiss. But I guess there's a coming case that will tell us better what does this substantial basis mean. But Laura may have further thoughts when she talks about the uniform code. Maybe they're taking different standards. The last point about challenges that I wanted to raise, in addition to many other challenges of this, is that I think there's a bit of a paradox right in the early phase of implementation, at least of this New York law, where you run the risk of extensive appellate activity. There's so many open, unsettled issues that the appellate activity by defendants may, in some way, cut against the early dismissal, what we're hoping for, the effectiveness of the law. That might be something that the uniform code will help us get closer to, something that we can sort of grab onto and know we're not going to have a bunch of different appeals going in a bunch of different directions, so that you're waiting 3, 4, in the appellate process in New York State, it's very slow. So if you're waiting 5, 6 years to find out if your anti-SLAPP success at the trial court level is upheld on appeal, or if there's changes in the law. So I guess I just think that unfortunately, it's a really good law, and it may be just inevitable to any new law in this category. But there's clearly going to be a lot of appellate activity that may slow down the benefit of this early dismissal notion that I think underlies the real free speech protection. So anyways, that's it for me.
Fantastic, Ken. You set out some of the significant issues here. And I think everybody now, Laura wants you to, we want you to solve this. Sounds like the uniform model approach it solves all of this. And Evan, you're welcome to jump in as well on this, but Laura, can you talk a little bit about this effort at reform, federal reform, or just proposals for a uniform approach?
Sure. So I'll talk about the Uniform Law Commission, which is aimed at trying to replicate, have the same law adopted in all 50 states. These are the folks that brought the Uniform Commercial Code to all 50 states. And it really is a remarkable organization in which you have very well-established practitioners, oftentimes judges, sometimes lawmakers, who've been selected in different ways from their states to serve. And what they do first is they decide what areas of law they want to work on a uniform solution to. And so that's what they did first. And they did a 1-year-long study, and they picked SLAPP as one of those. And then they spend 2 years crafting the model law. And in doing that, they meet twice a year for 2 years. Then they present that model law to all of their colleagues at the commission. They debate, they change things, they add things, and then ultimately, if the votes are there, they pass this model law, and then they work to enact it in all of the 50 states. The Uniform Law Commission, in this instance, passed the Uniform Public Expression Protection Act, UPEPA. It does not exactly roll off the tongue, but that is the model anti-SLAPP law that the Uniform Law Commission passed on July 15th with support pretty much across the board. There was one state that didn't vote in favor of it, and primarily because they couldn't get their commissioners to communicate about it beforehand. But what the Uniform Law Commission did in this process was they studied all of these other states, and they studied those cases in which there were problems with the constitutionality and questions about the standards and how the varying standards would apply. And they enacted what is a very broad-based applicability. It covers the exercise of the right of free speech, association, and petition, has very limited exemptions. It has exemptions for governmental employees acting in their official capacity or acting to enforce a law or regulation protecting imminent threat to public health or safety, and a commercial speech exemption. So you see some laws have a laundry list of exemptions. This one just has those 3 with a note, a commenter's note saying, do what you need to do in your states. If you need to adopt something different, obviously you're free to, but this is what the commission as a whole agreed should be in the uniform approach. And then they included all of those procedural aspects, the 60 days to file your motion, your stay of the proceedings, an expedited hearing, ruling within 60 days, and the standards, and what the court could look at. The court could look at the pleadings, the motions, any evidence that can be considered under summary judgment. And then they looked at the standards and they said, okay, we're going to make this very clean and something that's not going to conflict with federal law. The movant has the burden of establishing that the statute applies. The respondent then has the responsibility of establishing a prima facie case for each essential element of their claim. If they don't do that, they lose. Or if the movant, when the burden shifts back to the movant, is able to establish that there's no genuine issue as to any material fact, or that they are entitled to judgment as a matter of law, they prevail that way. There's an express right to an immediate appeal, and then there's mandatory fees. So that's the basic crux of the uniform law. It's actually being considered right now in at least 8 different legislatures. And so you've already are seeing the movement afoot to try to make it uniform in this area. The US Supreme Court has had multiple opportunities to take up the federal applicability issue. They have declined every time. And I think part of why they have declined is because there's just this patchwork of laws throughout the states. And if they take one, it's like whack-a-mole. They're not going to be, they still got to deal with another one. And so if we see the uniform law take hold in all of the states, or in the vast majority of the states, that could tee up the issue much better. But right now they keep declining it, and just declined it recently with regard to what was a pretty clear circuit split. You had the Fifth Circuit refusing to apply the Texas anti-SLAPP law in federal court in diversity actions in Texas, and the Ninth Circuit applying the Texas law in a federal diversity case in California. So very clear circuit split. They still said no, thank you. And Evan, you may want to talk on our efforts to get a federal law passed.
Can I, before Evan starts, I want to just ask about the exceptions, just under the uniform approach. I don't know the proposal at all. I mean, I've learned about it in preparation for this, but it sounds very interesting. Can you explain why these three exceptions?
So from a policy standpoint, the commissioners were concerned about, especially when you were dealing with governmental agencies that were acting to enforce a public health or safety issue, some sort of imminent threat to public health or safety. They were afraid in that framework of having that get caught up in this interlocutory appeal process. Similarly, they didn't feel like, because commercial speech has a lesser First Amendment protection, they didn't feel like speech involving the business of selling or leasing goods or services should receive this additional protection. And those were really kind of the primary categories that they felt deserve, where there should be a specific carve out. When this was presented to the floor at the ULC, there were actually two other exemptions in there. There was an exemption for insurance cases, and there was an exemption for wrongful death and bodily injury cases, both of which were brought by the trial lawyers, and they essentially didn't want their bread and butter cases getting caught up in SLAPP. You could see it would be the exception, not the rule, in which an insurance case or a bodily injury case would get caught up in all of this. But interestingly, the commissioners made a decision when this was presented on the floor and said, no, like we don't cater to special interest groups for our uniform laws. If a state feels like in order to get this passed, they need to add those back in or add in others, they certainly can. But from a policy standpoint, these special interest carve-outs are not what the commission wants to roll out as a uniform law.
Very helpful, Laura. Thank you. Evan, do you want to add to this? And Laura, she said we. I assume she's talking about the public participation project with which she is affiliated as well. Do you want to add some more?
Yeah, quickly, I'll just say, okay, so why do we need a federal anti-SLAPP law if momentum's moving, in way of the states? So, the two loopholes that this federal anti-SLAPP law could potentially plug. One is federal claims in federal court, and two is forum shopping, which I mentioned earlier. I'll give one quick example because I love it, and it's New York based, and it was it involves Dan Snyder, who owns the Washington City paper in Washington, D.C. He's the owner of the Washington football team as well. But anyway, they had written a satirical article about him. It was like A to Z, all the ways Dan Snyder's a jerk or something like that. And DC had just recently enacted a really good anti-SLAPP law. And Snyder didn't like this, and he's a bully, and he wanted to file a SLAPP. So what did he do? He found some hedge fund in New York that had an investment in the Washington City paper. So he found this like tenuous connection. And I'm just going to quote from the letter that his lawyer sent to this hedge fund. He said, quote, "We presume that defending such litigation would not be a rational strategy for an investment fund such as yours. Indeed, the cost of litigation would presumably quickly outstrip the value of the Washington City paper." So, his lawyers are basically saying, hey, we're going to file a slap against you. It's going to cost you a bunch of money to defend. It's not going to be worth it. So anyway, and I say, why is that an example for why we need a federal anti-SLAPP law? Because so instead of filing the SLAPP in DC, which recently enacted a strong anti-SLAPP law, he filed it in New York, right? Like, why would he file that in New York? He's a DC plaintiff. The Washington City paper's in DC. The reporter was in DC, right? So it was clearly a SLAPP where he was forum shopping, trying to avoid DC's anti-SLAPP law. So that's the why. And so then where are we? So we've had 3 federal anti-SLAPP bills introduced. The first was in 2009. Congressman Steve Cohen, who's a representative from Tennessee, introduced a bill in the House, which was only Democrats on board. It didn't really go anywhere. And then in 2012, Senator Kyle, who was interested in this issue, a Republican, introduced a very narrow anti-SLAPP bill in the Senate, just sort of as a marker for his work on this issue before he retired. And then most recently in 2015, it was the first time we had bipartisan anti-SLAPP legislation introduced in the House by Representative Farenthold and Congresswoman Eshoo. And so that was the furthest we've got with the federal bill. We got a hearing in the House committee on this. Laura actually testified at that hearing. And now we're working on a new bipartisan bill that will hopefully get introduced in both the House and the Senate, and hoping to do that this session.
Can I ask a quick question to either Evan on the federal anti-SLAPP? I'm puzzled because I don't know enough about it, and maybe it's self-evident, but do you have a federal anti-SLAPP law without a federal defamation law, or am I missing something? And then
I mean, RICO's
the point is going the other way. Does it go way off into like Section 230 and other things like that if you're going to have a federal anti-SLAPP? So I just kind of want to know what the contours of it were. But
yeah, quickly, I'll just say, no, it's not limited to any cause of action. And I think RICO is a good example where we've seen SLAPPs filed against environmental nonprofit organizations, enough so that they came together and formed a coalition called Protect the Protest. You can check it out, protecttheprotest.org. And they're starting to see that the amount of money they're defending against these frivolous federal SLAPPs, which are, guys under RICO claims, what were brought down, enacted to bring down the mob back in the day, are now being used to try and silence environmental activists. So yeah, I think there's plenty of examples of federal claims that, I've seen just one more example in California, for example, someone filed a copyright claim and they did that in federal court in order to avoid California's anti-SLAPP law, right? By guising their SLAPP as a copyright claim, it's now in federal court, it's a federal claim, and it's not subject to California's anti-SLAPP law.
I have to figure, Ken, also that preemption plays a major role here. And the courts, in copyright setting, courts will look through a claim, as Evan said, even if it purports to be one thing, but is in fact a copyright claim. And I'm thinking of the hot news doctrine litigation out of the Second Circuit. But it is an interesting question, though, that Ken pushes, right? So this is a state-by-state issue. The federal government intervenes. Will it have to narrow? Is there any way that it could narrow the scope of the intervention, or is it the sort of thing that can just flatly be addressed to all subject matter and laws?
It's a huge issue. We get into the weeds with a lot on this, right? First off, is this substantive or procedural? How would different circuits interpret this law? Would it have a removal provision, which would allow you to bring a completely state-based action into federal court? What would that look like? So these are, I think, what has slowed down our efforts at the federal level. So I think best case scenario, we're probably looking for a federal bill that applies to federal claims in federal court, right? And I think you run into less issues when you just deal with that.
And of course, that's got to feel a bit disappointing for those of you who would like to see real reform, but it'd be better than nothing, I suppose. Okay, so Claire, our wondrous organizer, has asked a question in the chat that I really want to hear you all talk about also. And that is, at the outset, I mentioned John Oliver's HBO piece of a year and a half ago, right? It was end of 2019, where he brought attention to Murray Energy and the CEO, Bob Murray, for stuff that they do. And and that they did that story in response to a story that had run related to Bob Murray. This is litigation that is ongoing, right? Or not? How do you envision a situation like this getting resolved? This is open to all of you. And maybe this is a nice cause célèbre that kind of unifies people and highlights this issue at a national level. But I'm curious to hear you talk about that case. You all familiar with it? Not as familiar with it. I think it's, yeah, go ahead, Evan.
I'm familiar, but I can't speak to where it's at right now.
Yeah, I don't either. I don't know where it is either. I'm inclined to think that it's a classic case of reprisal that just doesn't look good. It's unseemly and seems to bump right into the public policy set up by any SLAPP laws. Sorry, Claire, we can't give you a better answer than that. All right, so we're coming to the end here.
Well, real quickly, I will just say though, like I'm not that concerned with John Oliver's SLAPP, right? He has HBO behind him. I'm sure they have insurance companies, right? They have defamation insurance. Like they're going to be fine, right? The SLAPPs that get at me the most are the ones we don't read about and don't hear about, right? And that's when everyday citizens are getting sued for speaking out on issues of public issues. Not that I don't want him to prevail, obviously, and for the plaintiff to be punished, but I think a lot of these SLAPPs get a lot of attention that, and Oprah was slapped for saying she'd never eat a hamburger again by the Texas beef industry, right? So I think it's hard. It's great, but it also doesn't really show the need for an anti-SLAPP law because he has plenty of resources behind him to defend against that SLAPP, where most people don't.
Yeah, last I checked, Oprah has enough resources. And she may have more after this weekend. There are a couple questions in the Q&A that maybe I'll just float to the panel and you all can answer as you wish. And maybe what I'll do is ask, there are two questions. One is about the federal reform. And so maybe I'll just ask it since we were just talking about it. And it is a good question because we do need to hear from both sides on this. And so for the purposes of the CLE. So what are the principal objections to the federal law? So we've got I know we have we understand that the interests at work, right? I don't think you need to convince this group that trial lawyers like to see, or plaintiff side lawyers don't like this kind of intervention. But as a policy matter, what are the colorable arguments that we're hearing?
I can start, Laura, unless you want to take it. Okay. The primary objections come from AAJ, which is the National Trial Lawyers Association, right? And their concerns are the stay of discovery, which we've tried to address by allowing for limited, given the judge discretion on whether or not discovery should be allowed. But I think at the end of the day, they kind of see this getting looped in with tort reform, right? Which they don't like, right? And they don't like this idea of a mandatory attorney's fees provision. And not to back up here, but I will just give this one quick example. Like in New York, for example, even when we had the very weak law that protected petition activity, attorney's fees were still discretionary, right? So there was a group in the Bronx that represented a bunch of tenants that were organizing there. They got slapped for basically reporting housing code violations. It was a clear slap by the realty company, right? They ultimately won the lawsuit, but the judge didn't award them attorney's fees. So what does that mean? They spent over $1 million actually in attorney's fees, and they stopped doing their advocacy after that, right? So, groups want to argue for, like the trial lawyers, that they don't like mandatory attorney's fees. And oftentimes what we see in the States is that that's the only way a defendant can get an attorney to represent them on a contingency fee basis, right? If you don't have mandatory attorney's fees, like it really hurts the little guy more than anyone. So they don't like mandatory attorney's fees. And then the last thing I'll say, and Laura I'm missing a lot, I'm sure, but I think what's important you see in most state anti-SLAPP laws and what we have in the federal law, if you can show that there's a concern that defendants would use the anti-SLAPP motion to actually try and delay the trial, right? They're actually trying to make you incur more cost defending against something. But if you can show that the anti-SLAPP motion itself was filed to cause the delay, or if it was frivolous, then you can actually get your attorney's fees paid for as the plaintiff. So we tried our best to balance all these things and make sure that we're really only tossing out those clearly frivolous, meritless SLAPPs and giving plaintiffs opportunities, like with that discretionary discovery provision and with the frivolous anti-SLAPP motion provision.
So we'll say, Evan, this is very helpful. I think the person who asked the question, eBarry Lyon, just wanted the full context for this. And the day in court argument is probably this. I see this because I think a lot about it, and I've worked in DC with folks in DC on CDA 230 issues. There are different concerns, but the argument that those of us who are arguing for reform assert that the motion, the 230 defense is invoked at the motion to dismiss, and we never get to find out whether an intermediary is implicated. And I got to assume that that's the nature of the argument, right? I mean, it may be coming from trial lawyers, but that's got to be part of what is animating the most colorable argument, right? But the point you've made here is loud and clear that this is, when you're talking about attorney's fees, for example, these litigations are prohibitive for mom and pops, right? I know, Laura, I think you want to say something. I want to mention this other question we have here, which is kind of related. And the question is, how have SLAPPs been used in cases regarding online reviews like Yelp and other consumer sites? I don't know, Ken or Laura, you want to weigh in on this?
Sure. So this is actually Yelp for a time, and even now, maybe a little more behind the scenes, but they do get Section 230 protection, but they actually have been in the forefront on SLAPP reform initiatives, and went so far as to join the organization ALEC, to get them to adopt a model law in this area, because they felt like it was so, from a public policy standpoint, it was so important to have these protections for their commenters. Yelp came and testified in Texas when our law was under attack last session. And so even though they have those protections, they still believe that they want to foster discussion on their sites, and without having SLAPP protection for their commenters, they feel like that discussion will dry up. At least that's the way in which they have presented it. The only other thing I was going to add on Evan's statements about the federal bill is it really is, I mean, it's extraordinarily difficult to find that sweet spot that everyone can agree on because of the different concerns that people have. On the opposite side of the spectrum, you've got people that absolutely don't want to support it unless it applies in diversity cases. Then you've got other organizations that want to have a carve out for copyright because they don't want it to be involved or be caught up in SLAPP in piracy related litigation. And so it's very difficult to get that collaboration of support on something. But I think that one thing that you brought up, which was correct, is to have something is better than to have nothing. And that's where the aim is right now, is to get that foot in the door with some protections in cases in which there wouldn't otherwise be protections right now. May not be perfect, but it's a start.
Right. And you make a great point, Laura. I mean, the overlaps with all these others are areas of law where people are fighting about the access to courts questions, copyright being a great example. You can see why it's thorny. So we're out of time here. Ken, do you want to get a last word?
Yeah, I just in terms of federal versus state, I think that's why I'm so encouraged by the work that Laura's doing with the Uniform Act. I think we're gonna, when we get to the critical mass is already we're over half. We get to maybe 45 states or something. Then at that point, we'll have ability to then go back state by state and find reform in the states that have enacted laws without as robust protections for plaintiffs. And it's going to be it's a long haul. That's why it's great to people like Evan and Laura out there, you know, fighting the good fight, because it needs to be fought, and it's wonderful to see you. So that's my parting shot.
Thank you. So thank you, Ken, Laura, and Evan, for a really educational, helpful, thoughtful discussion. Claire, turn it back to you.
Thank you all. We are going to take a brief break before the keynote speaker at 12:15. So everyone just hold tight till then. But for these panelists, thank you so much. I really appreciate, you know, everything that you had to share and all the work that you've all done as well. Thank you.
All right, it is 12:15, so welcome back and good afternoon, everyone. My name is David Devich. I am a third-year law student and the editor-in-chief of the Fordham Intellectual Property, Media, and Entertainment Law Journal. It is my great honor to introduce today's keynote speaker, Kate Bolger. Ms. Bolger is a partner at Davis Wright Tremaine and the proud mother of a 13-year-old daughter and a 10-year-old son. She is an experienced First Amendment and media litigator who has represented news and media entertainment companies in a broad spectrum of content-related matters, ranging from investigative journalism to coverage of celebrities. She also teaches mass media law as an adjunct professor at Fordham Law School. So without further ado, I give you Kate Bolger.
Hi guys, so I'm Kate Bolger, and as David said, I'm a workaday First Amendment media and First Amendment litigator here in New York. Practically, that means I litigate cases for media companies accused of defamation or invasion of privacy or other torts related to the publication of speech. I think it's about the best lawyer job you can have. But most of the time, my days are filled with interrogatories and notices of motions and depositions and nasty letters. I don't often get to sit around and think big thoughts about the law, divorced from trying to win a case. So this is kind of a nice opportunity for me, and I thank you guys very much for inviting me. I will say that it's a little weird to give my big thoughts to my bookcase, but I'm gonna do my best to try to keep this entertaining throughout the day. So it turns out that when you all give me a chance to think big thoughts about the state of free speech in the United States in 2021, I have reached the very lawyerly conclusion that it's a mess. And I'm very worried that the First Amendment model we've clung to for so long is breaking down. More than that, I'm not sure how we're going to fix it. I am thus hitting all the high notes for a keynote speaker, identifying a problem, panicking about it, and proposing absolutely no solutions. Nonetheless, I'm going to keep going. Those of you who have taken my mass media law class, and hi guys, I'm sorry I'm not seeing you in person, know that I always start out the class by talking about two linked ideas. First, we talk about what the animating principles are of the American concept of free speech. And then I tell you that all of those principles didn't really come into play in American law until the 20th century. And I'm going to do that quickly now so we can set up the rest of our discussion. So first, I want to say that my general structure is not mine. It's a structure that was sort of proposed by Professor Thomas Emerson, who was a Yale professor, kind of widely considered one of the great thinkers on civil liberties in the 20th century. But I'm going to draw on some other things too. I just want to give Professor Emerson some credit. First Amendment jurisprudence is informed by the idea that the protection of free speech rights is necessary to assure individual self-fulfillment. I call this one the sappy First Amendment principle. Of all of these, actually, this one strikes me, a particular nerve with me. When my husband and I have traveled to Eastern Europe, he usually points out the cells he believes I would have been detained in because I would have been unable to be quiet about my objections to anything. And it's such a fundamental feeling that there's really almost no need to talk about it. Words and ideas flourish even in the most repressive of societies. They sneak around in students' backpacks and encrypted apps and are delivered in ways to help people avoid surveillance. Peter Zenger in Manhattan and Alexei Navalny in Moscow and countless others in history will risk jail rather than stop communicating. Our First Amendment jurisprudence is designed to protect it. And that desire is the self-fulfillment we're supposed to be protecting in the First Amendment world. Another idea is that you must protect speech to protect the marketplace of ideas. this fictional marketplace where all ideas sort of bump into each other and the right one wins. The idea is actually an English one. It was originally proposed by John Milton in the Areopagitica, which I still don't know if I pronounced correctly. It was in 1644, and he proposed actually that truth was in the field, a nicer, sort of more agrarian version of the marketplace. The marketplace of ideas actually doesn't enter First Amendment jurisprudence until 1919, when Justice Holmes mentions it in his dissent in Abrams versus the United States. And there he says that the best test of truth is the power of the thought to get itself accepted in competition of the market. That at any rate is the theory of our Constitution. I love that Holmes quote because it shows two things. One, the marketplace of ideas, and two, this fiction that this was always a part of our Constitution. In fact, it hadn't been mentioned until 1919. That's neither here nor there. Third, we protect free speech rights because they are necessary to participate in self-governance. This theory, one that seems so basic and so self-evident, is also really brave, right? If government is derived from the people, then the people ought to be able to talk about it. But that's a nervous-making idea that there's all of this noise in your country. It was actually such a fundamental truth to the founding fathers that some of them, including former Harlem resident Alexander Hamilton, thought we didn't need to include a free speech protection in the Constitution because it was clear to him that there was nothing in the Constitution that would have allowed the government to thwart your free speech rights. And finally, and related to that, the First Amendment protects free speech rights because doing so is necessary to create a more stable community, because suppression of the ideas of the minority would otherwise lead to greater conflict, potentially armed conflict. In other words, the minority ought to be able to say what they want without fear of reprisal, or they're going to get upset and take up arms. I think about that one a lot lately, and we'll talk about it again a little bit later. So these four concepts inform our modern speech law, or at least they have done since Holmes and Brandeis switched sides, as it were, in around 1920, and started to write minority opinions supporting the free speech rights of communists and labor organizers. The United States Supreme Court actually started to adopt these ideas as guiding principles, kind of starting in 1939, when Hitler's trouncing around Europe and people are losing liberty after liberty in Europe. And they started to adopt them in cases involving the Jehovah's Witnesses and other small minorities. That adoption continued through the 1950s. And as time has gone on, free speech law has gotten more and more libertarian, which is to say, it has shown an increasing intolerance for any kind of government limitation. On the internet, and we're going to talk a lot about the internet, that means that courts and legislatures are extremely reluctant to allow regulations of speech in any way. The first significant case involving the government regulation of the internet was Reno versus ACLU, brought in 1997 to challenge the constitutionality of the Communications Decency Act, a law originally designed to protect children on the internet by regulating obscene or indecent speech. The decision is significant in millions of ways, and we could talk about it all day long. But today we're just going to focus on two of those. The first, it's significant because it applied the First Amendment to efforts to regulate the regulate the internet in the same way it applies the First Amendment to efforts to regulate newspapers, as opposed to, for example, radio or television. And the second is that the Supreme Court, in drafting ACLU versus Reno, adopted the extensive findings of fact made by the district court. The CDA had a quick appeal mechanism built into the statute, so it jumped right to the Supreme Court. And those particular findings of fact were about the nature and character of the internet. Interestingly, they were the findings of facts and conclusions of law that had originally been drafted by the ACLU and agreed to by the government. So in short, the Supreme Court's findings of fact and conclusions of law were proposed by the litigants in the ACLU versus Reno case. It's extremely significant in how we think about the internet in the legal context, because those statements of fact were both quite broad and have now been adopted by court after court struggling with legislating speech on the internet. And some of those facts found by the court were themselves really speech maximizing. The Supreme Court found, for example, that the internet is a unique and wholly new medium of worldwide human communication. I mean, who can regulate that? That's important because it shows that even in 1997, when those of us old enough to remember it still had dial-up modems, the Supreme Court positioned the internet as being a virtually unfettered marketplace of ideas worthy of protection. Another part of the Communications Decency Act left untouched by the decision in Reno was, of course, the safe harbor provision, which we know as, and say it with me, folks, Section 230. Section 230 provides that, quote, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. And it was little more than an afterthought in the original drafting of the CDA. The provision was originally designed to protect ISPs like back then Comcast or AOL, companies that were providing access for average Americans to use the computer to get to the web. Of course, as we all know, and as Jeff Kosseff just wrote in a book called 26 Words That Created the Internet, and many smart people have talked about, Section 230 is probably single-handedly responsible for the growth of the internet as we know it, because it allowed internet innovators to create platforms like Facebook, Twitter, Reddit for people to share information. And it has rendered the internet truly barrierless in a way no other media can boast. In short, right now, as we sit here on this lovely day in New York City, we find ourselves with a First Amendment model on the internet and elsewhere that eschews any kind of regulation. And we're proud of it. Part of being American is the sense that we carry our First Amendment rights around in our pocket like a super deflector shield, as in, you can't do that, it violates my First Amendment rights. And we get that wrong all the time. To use an example I will talk about later, lots of people think that deplatforming someone from Twitter or Facebook is a First Amendment violation, and of course it's not. It's just that we have all bought into the myth of broad anti-government First Amendment protections as not only our history, but also our future. Here's the problem. What if we're wrong? In 2017, the Knight Institute published an article by Timothy Wu, who actually just joined the Biden administration, by the way, so keep your eyes open for that. It was called, Is the First Amendment Obsolete?, which made some horrifyingly persuasive arguments that our current First Amendment jurisprudence is obsolete for several reasons. To be clear, I'm going to paraphrase the article, but please read it. It's really interesting, and I have a very love-hate relationship with it, so I want to hear everybody's thoughts. The main point of Wu's argument is that all of First Amendment jurisprudence is based on scarcity, the idea that there isn't enough speech and the opinion of dissidents will get silenced absent protection. Now, of course, there is no scarcity. Any idiot can tweet and frequently does. More than that, there are bots, trolls, ratioing, threatening, and all manner of ways for speech to be overwhelmed or chilled or silenced. Wu has a really nice way of explaining this. He says, in other words, it was once hard to speak, it is now hard to be heard. Add to that cocktail, Wu makes the point that much speech is now on private platforms like Twitter or Facebook that are not only outside of government control, but also have developed filters and algorithms that deliver news tailored to the reader, which Cass Sunstein calls the daily me. Wu argues that our First Amendment law has no method of dealing with this siloing of news, which has been packaged and delivered directly to our eyes and ears by for-profit actors. And holy cow, that's really scary. Because if Wu is right, then those four animating principles I talked about at the beginning of this speech, 15 minutes ago, well, they're all thwarted by the way we actually are consuming information on the internet in 2021. I'm going to take them in reverse order from the way I said them at first. So the first principle we're talking about is the idea that the First Amendment law protects a stable community where the views of the minority are protected. Internet speech is not doing that. On the contrary, the current community of speech on the internet is unstable and unsafe. Just ask Zoe Quinn or Brianna Wu of the Gamergate harassment campaign, or essentially any journalist on Twitter who's been harassed on the reg for the last 4 years or so. In fact, the community is so unsafe and so unstable or at least perceived as unsafe and unstable for unpopular views, that conservative speakers decided they needed to create their own messaging platform, Parler. Our next guiding principle, the one that I said was so self-evident that well-known rap musical star Alexander Hamilton didn't feel it needed to be included in the Constitution, is that free speech is necessary for self-governance. But I'm not sure that current free speech law is producing the best information for self-governance on the internet or elsewhere. And to make that point, I probably only need to say one letter, Q, as in QAnon. There, at least, there are, lest there be a question, sorry, no lizard people currently running the American government, nor is Trump going to be inaugurated president on March 20th or whatever the date is next. And yet these theories have been aggressively disseminated without check on the internet for months, and real human beings believe them. More terrifyingly, though, and this has only increased since Wu wrote in 2017, we're facing a shift in our discussion that neither the founders, nor Holmes, nor Tim Wu could have foreseen. Speech on the internet is not true. In fact, truth seems to have no value in our social discourse. Truth has been, in fact, under deliberate attack by the former president and his administration for about 5 years. According to the Washington Post fact checker, President Trump made 30,573 false and misleading claims while in office, with an estimated 504 false or misleading claims being made on just the day before the presidential election. And yet 74.1 million Americans voted for him. Truth, it seems, doesn't matter. Then Trump and his allies told the biggest lie of all. Without basis in fact, Trump insisted that the presidential election was stolen from him by voting machines or mail-in ballots or some other mechanism. And real Americans really stormed the Capitol to attempt to thwart the election as a result. As of February 4th, 2021, 76% of Republicans in a Quinnipiac poll said there was widespread voter fraud in the 2020 election, and there still hasn't been any truthful evidence. And honestly, that barely scratches the surface. Lots and lots of untrue speech is generated by our friends in Russia or China or bots or the proverbial guy in the basement in his underwear in his parents' house. And false speech, even in some cases, knowingly false speech, is not actionable on the First Amendment. Consequently, our current speech law simply cannot address these falsehoods and cannot stop their spread. And that is a grave risk to the very idea of self-government. Next, the current model destroys any credible argument that the right idea will win in the marketplace of ideas. I should start out by laying my cards on the table. And as a graduate of the University of Chicago Law School, you need to know that I'm in serious jeopardy of losing my law degree for the sentence I'm about to utter. But I'm not really sure I ever really bought into the idea of the marketplace of ideas to begin with. The market is too imperfect. The access costs for diverse views, and by that I mean ideas that are diverse and for speakers that are diverse, which is to say not white men, have always been very high. And the transaction costs, i.e. the cost of bargaining in a universal marketplace with millions of players, are too high to provide a meaningful result. But if Wu is correctly describing the way speech moves on the internet, and I think he is, we aren't even all in the same marketplace. As Judge Sack of the Second Circuit put it, this is the Tower of Babel, not the marketplace of ideas. I get news only in my silo. My Daily Me, the news I read, caters to and only to Democratic New York First Amendment lawyers who like journalism, museums, want to be Sherlockians, and who are thrilled beyond the telling of it that the Knicks are one game over 500. I'm not learning new ideas that are coming to me in a marketplace. I'm running the risk of growing more entrenched in the ideas I already have, particularly when, of course, I haven't really left my house for a year. And it's getting harder and harder and harder for the right idea to win out in a marketplace that doesn't exist. The one animating principle, and by the way, is there even a right idea? The one animating principle I still think that is alive and well in First Amendment free speech rights as we sit here in 2021 is the sense that we speak for self-fulfillment purposes. And here we hit a snag. I'm not sure that turns out to be a good principle after all. There is no question that the current model of curated content packaged and delivered just for me by unregulated private for-profit actors has encouraged lots and lots of self-expression. To use a basic example, I tweet more than I should. I sometimes won't do it when I'm angry. I post pictures on Instagram so my friends can see pictures of my kids. And sometimes it's stuff that's so dumb, I wouldn't have posted it or taken a picture of it if I'd thought about it. Truly, do you all care that I deeply believe, as I've recently retweeted, that Rolf, not Kermit, is the best Muppet? Shouldn't I have just kept that to myself? In short, I think free expression is on the rise in the internet, but I'm not sure that's good. Implicit in the idea that self-expression matters in a democratic republic is the idea that we, the human citizens of this great country, will use that right in a way that is civically virtuous. We want to allow self-expression so that citizens will hear, speak, and understand the world around them truthfully and make choices for the common good. We don't want them making choices just for me. Our current regime has no way to filter that out. Anyone, anywhere can say anything, and there's no evidence that they are thinking about the common good in the process. On the contrary, they're mostly commenting about the daily me. In short, those 4 principles animating our First Amendment model that I talked about today and in all of our mass media law classes, well, they actually may be undercut by our current First Amendment legal scheme. So what do? This is the part of today's talk when I'm supposed to tell you my ideas for how to make things better. And I do have one small idea that I'll mention toward the end, but I will tell you candidly that I don't know the answer and I feel pretty worried. It feels to me that we need serious people thinking seriously about how to move free speech law in the direction of the greater good. And call me cynical, but I'm not sure that we have that right now. Reading green eggs and ham on Twitter is not going to get the job done. Still, let's talk about some ideas that people smarter than I have proposed. The first of those, of course, is to allow the current regime to remain, i.e. keep the government out of regulating the internet and allow or encourage the for-profit corporations that silo and package news through algorithms and filters to self-regulate. That, of course, it is what is happening right now with deplatforming. Well, let me take a sip of water. I am so much funnier in person, by the way. That, of course, is what is happening right now with deplatforming. The ban from Twitter of people like Lynn Wood or Alex Jones, and President Trump. Deplatforming raises a ton of very, very hard questions, particularly about how much power private companies should have to shape a public debate. But it doesn't raise any First Amendment questions. In other words, the First Amendment answer to the question posed by the deplatforming of the former president is that the First Amendment is irrelevant. That's pretty stark. We all need to figure out how comfortable we are with that and what we're going to do if we're not. Interestingly, Facebook at least is also concerned about its powers to make such decisions, or at least the public perception that it has the power to make such decisions. About a year ago, in a model pioneered by the British press seeking to avoid regulation in response to the phone hacking scandal, Facebook made some efforts to self-regulate its decisions regarding suspending users. It funded an oversight board that is said to operate independently of Facebook, and it has the ability to review decisions related to the suspension of users. The oversight board is composed of 40 or so individuals, from Nobel Prize winners to a former prime minister. Some are American, some are not. And Facebook says that they are currently reviewing the ban of President Trump and should have a decision soon. But how comfortable are we with that? First Amendment tradition tells us that we should be skeptical of government intervention in speech. American tradition says you should be skeptical of government in general. But are we okay with unelected private folks intervening instead? Even if they're really smart? I don't know the answer to that. Another option, touted by President Trump in his ineffective, I guess, executive order, is to repeal Section 230 and require platform providers to review and curate the information published by their users or face liability. In my opinion, this one put that starkly, simply isn't workable. The internet simply won't work without some protections for the innovators that build tools to spread information around the globe. And by the way, I'm not really sure there's been a really serious federal legislative proposal to do so. Most proposed language has been so political in nature that it can't possibly represent critical thinking, and it has no chance of passage. And those that have been slightly more serious efforts, like Josh Hawley's most recent proposal, use words that have no First Amendment meaning, like requiring platforms to act in good faith, words that would face serious constitutional challenge. There is, however, a very real sense that the CDA protections are not working because they were not created to and do not address the targeted way in which internet platforms collect, repackage, and deliver information to viewers. Professor Sylvain has actually written and spoken extensively on this, so I feel a little bit out of my league with him in the audience. There is, however, a very interesting dissent written in Force versus Facebook in the Second Circuit, in which Judge Katzman expresses support for the idea that the algorithm that Facebook itself invents to connect users on its platform is itself speech, separate from the speech that is actually carried on the platform. I seem to have lost the page. Hold on one second. Well, this is kind of a cliffhanger, everybody. One second, I can fix this. Sorry, folks. I'm a two-screen kind of a girl today. Okay, here we are. So as I was saying, we were talking about the decision and the dissent in Force versus Facebook. There, Judge Katzman expressed support for the idea that the algorithm that Facebook itself uses to connect speakers on the internet, and in that case, it was actually a wannabe terrorist with a real terrorist, was itself speech not created by a third-party user. In other words, the algorithm would be outside of the CDA safe harbor. The Supreme Court just refused to take cert in Forts, so we're not going to hear from about that again, but it was an interesting idea, and I'll be curious to see where it goes. In addition, by the way, I read this morning that there are a number of bills in state legislatures seeking to penalize platforms that remove speech, that ban speakers a la President Trump. Those, of course, will go nowhere because they're unconstitutional under our current structure, but there are certainly noises that there's an effort to reverse or ratify the CDA. Still, another option is the idea that courts and legislatures could regulate the internet consistent with public forum rules. Just 1 week ago, two authors, Genevieve Laker and Nelson Tebbe, professors at U of C and Cornell respectively, published an article on the Law and Political Economy project entitled "After the Great Deplatforming, Reconsidering the Shape of the First Amendment," which questioned whether the public forum doctrine should be applied to prevent private platform providers from banning or deplatforming people on the internet. Just generally, the public figure doctrine, which is kind of squiffy, that's a fancy legal term, was first created in 1939, but not really actually fleshed out until the decision in Perry Education Association in 1983. Posits that there are 3 categories of government property that have sliding protections for expressive activities. So to simplify that, it means that the more like government property is to a traditional public forum, a town square, for example, the less regulation is constitutionally tolerable. The Laker-Tebbe article and many others actually argue that we should perhaps entertain the idea that because Facebook or Twitter or Reddit provide a forum that operates like a traditional public square, First Amendment rules protecting free speech should apply as against those platforms as well. And they talk about an old Supreme Court case called Marsh versus Alabama. Marsh was actually about a company town owned by the Gulf Corporation that kept arresting Jehovah's Witnesses who were canvassing in the actual town square of the company town. The town turned the protester over to the Alabama state courts where she was convicted of trespass. And the Supreme Court reversed the trespass conviction because it concluded the corporation, in turning her over to the state and therefore invoking the action of the state, was using state law to dictate the views that could be expressed in their town square. This was because the court noted whether a corporation or a municipality owns or possesses the town, the public has an identical interest in the functioning of the community in such manner that the channels of communication remain free. It followed from this that the managers appointed by the corporation could not curtail the liberty of press and religion of these people any more than the government could. So by extension, if you analogize internet platform providers to the corporation in March, perhaps it would change the way the First Amendment could function as it relates to speech on the internet. I'm not sure I fully understand what it would look like, but I think it's really interesting that there's some antecedents in some Supreme Court cases that may suggest that the public forum doctrine is a decent fit. In fact, in Packingham versus North Carolina, decided in 2018, Justice Kennedy basically held the internet was a public forum. He wrote, and this is the quote, "A fundamental principle of the First Amendment is that all persons have access to places where they can speak and listen, and then after reflection, speak and listen once more. The court has sought to protect the right to speak in this spatial context. A basic rule, for example, is that a street or park is a quintessential forum for the exercise of First Amendment rights. Even in the modern era, these places are still essential venues for public gathering to celebrate some views, to protest others, or simply to learn and inquire. While in the past, there may have been difficulty in identifying the most important places in a spatial sense for the exchange of views, today the answer is clear. It is cyberspace, the vast democratic forums of the internet in general, and social media in particular. So I think that's very interesting. I'm not sure how that will all play out, but internet as public forum seems to me something we'll be hearing about in the future. Another idea is to regulate the internet by applying a modern version of the fairness doctrine. If I had to pick a theory that I thought was most likely to develop some momentum, this idea of regulating the internet is one of them. I'm not sure yet that I agree with it, but I think it's the right idea. The fairness doctrine, just as a sort of quick 2-minute background, which was introduced in about 1949, was a policy that required the holders of broadcast licenses to present controversial issues of public importance, but to do so in a way that was, the phrase was, honest, equitable, and balanced. The rule had several iterations over time, but when the rule reached the Supreme Court in Red Lion, Broadcasting versus FCC in 1969, the rule required broadcasters to provide reply time for personal attacks. The Supreme Court held that the rule didn't violate the First Amendment as it related to broadcasters, in part because of the scarcity of broadcast networks, right? If you were fortunate enough to control a network, you were required to have someone who disagreed with you on the airwaves. 5 years later, in Miami Herald Publishing versus Tornillo, the court actually reached the opposite conclusion, saying that the fairness doctrine was unconstitutional as it applied to newspapers, which the court concluded weren't scarce. The rule was repealed in 1987 by Reagan's FCC commission, and that repeal was upheld by the DC Circuit. Just coincidentally, of course, the repeal paved the way for conservative talk show radio, and a young man named Rush Limbaugh suddenly had a platform, and the rest is history. Those who advocate for a return to the fairness doctrine for the internet focus on the idea that requiring reports to be equitable, fair, and balanced would fix some of the harms detailed by Wu in his article. In other words, it would fix the idea that there was false speech or imperfect speech out there on the internet without allowing time for rebuttal. Gosh, I'm not really convinced. The internet, as the Supreme Court has already held in Reno, when they chose to apply the standard of care they would apply to newspapers, is not a scarce commodity. It's hard to believe you can impose any kind of fairness doctrine on it. And the vast majority of speakers on the internet aren't journalists or professional publications. They're just people. More than that, I don't know that I'm all that comfortable with FCC regulators making decisions about content, fairness or otherwise. I think those decisions should be made by journalists doing journalism. So some of these ideas are really fascinating, but I haven't yet heard of one that I think is perfectly workable. I have one tiny little idea, and it's going to seem silly. Americans should take civic classes. It seems to me that at bottom, what has happened to our national discourse is not just that the law is imperfect, or that social media companies make money packaging and publishing the Daily Me, regardless of the truth of the information it contains. It also happens that we as Americans are failing to think critically about our government and our duties as citizens. In huge numbers, we post and repost things about matters of public interest that we have no reason to believe, and espouse theories on either side of the political aisle whose truth we have no ability to assess. Now, I'm not talking about tweeting things about the second most important cultural event to happen in the last 24 hours, this being obviously the first. I mean, Meghan and Harry's interview. I'm talking about the real important stuff of government. In fact, even as we have all become publishers, very few of us are journalists. And we are simply not in a position to make the kinds of judgments as to the truth or falsity of the words we speak that we need to be able to make before we talk about serious matters affecting our country. Uncareful, endless republication of unverified information is dangerous. We all need lessons on how to act like citizens in a republic, if we can keep it. I understand that this is a political nightmare, and that Ted Cruz and Chuck Schumer are very unlikely to agree on what a citizen needs to learn. But I do think there's a bit of a way forward. I think Americans should learn how to take the citizenship test. You have to take the citizenship test or you can't graduate from high school. I appreciate this is an incomplete solution, and it isn't going to solve any of the other things I talked about, but perhaps a reminder to all of us that American free speech ideas were meant to protect self-expression, encourage self-government, create a marketplace of ideas, and protect the minority view could create a sense of shared purpose to help us through this particularly difficult time. So that's the end of my remarks. I noticed there's questions. Before I take them, I wanted to just say quickly, I wanted to thank some people who helped me. Nabia Sayed for the markup, who I talk to about these ideas all the time. Rachel Strom, my partner, for reading this. My children, who told me to include lots of pop references so that people would think I'm cool. My husband, John, who also read this. So thank you all. I hope someday to see you again in person, and I will look at the questions. Okay, so sorry. So the first question, how do we reconcile the First Amendment rights and the various nefarious groups' rights to use speech to psychologically manipulate the masses? So in fact, I think that's a little bit my point. I don't know the answer to that, right? So we are dealing with, as I said in my remarks, kind of a breakdown of truth. We're dealing with leaders, people with power who have enormous capacity to intentionally mislead. And at the moment, I don't know that we have a mechanism for addressing that. And that's one of the things that makes me most nervous. And it's where my sort of hokey idea that maybe we all sit down and learn what manipulation is, and learn what propaganda is, and learn how to assess truth. Maybe that's the only real answer. I don't know that the First Amendment can fix that. So then, do you think reformed Section 230 or pressure from users or competition is more likely to be what ultimately makes social media sites regulate their content more strongly? So absolutely no question, I think it will be pressure from users or competition. Honestly, at the moment, I just haven't seen a credible proposal to amend the CDA. What I am seeing instead are people like Zuckerberg thinking, holy cow, they're going to amend this in a ham-handed fashion. I better think through how to forestall that. It's actually, as I mentioned in the speech, exactly what happened in the UK after Millie Dowler and the whole phone hacking scandal. The major publications in the UK all got together and created something called Ipso, a self-regulation group. And they proposed that and said, you don't have to regulate us, we're going to do it ourselves. That's what Ipso is. So I think there's no question that the first thing that will happen is efforts to self-regulate based on static from the real world. And the last one is longer. Please share your view on the current situation of the USA, where private companies such as Facebook, Twitter, and other online social media companies have injected themselves into society to the extent that local, regional, national, and international economies have become independent on the platforms. Should companies like these mentioned be allowed to continue to argue that they are truly private and benefit from the protections of private companies when their own self-promotion and seeking to make local, regional, national, and international communities interdependent upon them would allow them to escape regulation, while also having the power and ability to hinder or harm such communities? Take private hedge funds as an example. Government recognized interconnectedness of such companies, and therefore regulation to some extent is now required. Does the interconnectedness of private technology platforms now warrant regulation of some sort? So I think that's the whole idea of, I read that very quickly, sorry. I think that proposal, can we regulate them? Are they really private? To me, that is very much tied into this idea of what's the public forum. And that language from Packingham, I think, is really interesting. The Supreme Court seems open to the idea that these private entities are creating a public space. I don't know what that means, though, because what that might mean is that they can't ban President Trump from Twitter, right? Even as he's making certain statements that some people consider to be incitement, right? So it's a really difficult situation. I think you're right that there's some idea in there that these really aren't private companies, that they're undertaking some civic act, but I'm not quite sure. I haven't been able to think through where that would lead us in terms of regulation. Any other questions? I think I did it. All right, well, as I said, it was really lovely to talk to you all and or my bookcases. And I hope to see you all someday in person at Fordham or elsewhere, and hope you all get vaccinated soon.
Thank you, Kate, so much. We really appreciate you joining us and answering all the questions that you got. We're going to take another short break, and we'll be back at 1:15.
Hello, my name is Rachel Morgan, a third-year Fordham Law student and a senior Notes and Articles editor for the Fordham Intellectual Property, Media, and Entertainment Law Journal. I'd like to introduce Professor Ron Lezepnik, the moderator of our next panel, Celebrity Paradox: Copyright, Social Media, and Paparazzi Photography. Professor Lezepnik is a clinical associate professor of law here at Fordham and currently serves as the supervising attorney for the Samuelson Glushko Intellectual Property and Information Law Clinic, where he oversees legal matters in areas including, but not limited to, copyright, trademark, and information law. Thank you all for joining us today, and please enjoy our last panel.
All right. Hello, everyone. Welcome to the last panel. I've got a wonderful group of people here that I'll just introduce very briefly and then give a few quick remarks. We have Nancy Wolf, wonderful partner at Cowan Debates, Abrams and Shepard, who does a lot of transaction-oriented IP space, I think I can say, Nancy, right, in counseling. We have Dan Schnapp from Nixon Peabody, who does the more litigation side of things to talk about today's panel. We also have Angie Byun, who, in addition to doing a lot of transaction side on the legal side, also does transactions on the business side, but also teaches here at Fordham. So we're very, she has many hats for purposes of this panel. And we have Julie Zerbo, who focuses on fashion and is the editor-in-chief of the Fashion Law, who I guess is bringing a bit of an academic, a little bit of a law perspective, academic law perspective, a little bit of litigation perspective, and a little bit of transaction perspective for us. And thank you all for joining me on this panel. The name of the panel is Celebrity Paradox: Copyright, Social Media, and Paparazzi Photography. I thought I would just very quickly note a few things from the legal perspective. One is when we think of photography, right, which is at the core of today's panel discussion, it has a very interesting history for law, right? It wasn't part of the original Copyright Act in the United States, one, because photography didn't exist back then, but also even when photography did come to exist as a technology, there was pushback in terms of whether or not what occurs in the capturing of an image into a photograph is something that is worthy of copyright, whether the artistic choices that we saw related to paintings and books and whatnot also could be expressed in photograph, which were originally viewed simply as capturing a moment in time. But once we've moved past that era, we now recognize that copyright is something that is protectable. And it is now something that we attribute to every photograph as soon as it is captured, both in a studio, out in the world as professional photographers are taking wonderful photos, but also every time you snap a photo on your smartphone. And today's panel focuses on how that aspect of photography, the taking of the photo and owning the rights to it, interacts with people who are very often the subject of the photos, what we deem celebrities. And normally, when we talk about celebrities in the IP space, we usually focus on the concept of the right of publicity, the idea that as somebody who is known in the world, much like trademark law protects brands and for goods and services, a celebrity should be able to have some control over their brand and control whether or not their image or likeness is something that can be used for commercial purposes. This is, of course, limited by concepts of the freedom of the press to report on the person, but usually when somebody is making money off of the celebrity for purposes of endorsement, they have to get the celebrity's approval. But we've entered a new phase of complexity in the modern era, which is these celebrities have, in addition to photo shoots for things like Vogue or appearing in news articles, they have social media platforms that they participate in, be it Instagram, Facebook, Twitter, and whatnot. And on occasion, they want to post a photo of themselves. And as it turns out, not every photo they post of themselves was actually taken by them or one of their agents. And so there comes a question of who owns or who has a right to those images of the person. Can the person who is the subject of the photo also use them? So that's to tee up what sounds like a bit of a mess, right, in terms of the law of all these arrows pointing in different directions. And so we thought as a panel, what might be helpful is to give a fact pattern that we can then discuss amongst ourselves, add a few layers of complexity to it, and then open it up to questions from the audience. And so Dan was very kind and was willing to share the facts of one of his more recent cases that kind of touch on these issues. So Dan, if you wouldn't mind taking it away and sharing with us one of your cases.
Yes, thank you, Ron. Hi, everyone. Again, I'm Dan Schnapp from Nixon Peabody. I'm absolutely honored and delighted to be on such a distinguished panel. And as Ron said, the name of the presentation today is Copyright, Social Media, and Paparazzi Photography. I am working on a matter that is pending in the United States District Court for the Southern District of New York that does seem to assimilate and encompass many of the issues that we'll be discussing here today. I'm going to give you a brief recitation of the facts, talk a little bit about some of the arguments that we made, and I will say, of course, that the matter remains pending before the court. No decision has been issued, and so everything I say today, I think, is essentially taken from the documents that are on the court's docket system. I don't think I'll be, hopefully will not be invading any attorney-client privilege. The matter was brought by, well, I should mention, first of all, the attorney who brought the matter is a gentleman by the name of Richard Leibowitz, who has a number of issues going on right now with his own status in the Southern District and in other courts. He has been called by the judges of the Southern District of New York a copyright troll. And a copyright troll, loosely defined, is somebody who will go out and file perhaps meritless lawsuits. He represents a number of photographers. In fact, that is his specialty. In this particular case, he represents a celebrity paparazzi photographer by the name of Robert O'Neill. Mr. O'Neill is no stranger to my client, Emily Radzikowski. As many of you may know, Ms. Radzikowski is a very well-known Instagram influencer and celebrity, model and an actor, and has a clothing business. And she has been photographed many times in public by the paparazzi. She also has, at the last count, somewhere between 26 and 27 million followers on Instagram. The fact pattern of the case is essentially that one day, while she was in downtown Manhattan, she went to purchase a bouquet of flowers for a friend of hers, who was, it was her birthday. And she purchased the flowers. She walked out of a flower store and went back to what was then her apartment. And she happened to have the lucky or unlucky misfortune of bumping into Mr. O'Neill, who was apparently just hanging around downtown Manhattan and had to have had his photography equipment with him. Mr. O'Neill followed Ms. Radzikowski, and what you'll see here on the screen is a series of shots that he took of her. Apparently there was other paparazzi present. I don't know who they were, but in any event, as you'll see here, there was a series of photos taken in a rapid succession, and the majority of them were taken fairly close to the front door of Ms. Radzikowski's apartment building. Mr. O'Neill, as he typically would do, took the photographs and he uploaded them to his news agency, which is known as Splash, S-P-L-A-S-H news agency. And essentially the way that worked was that Splash would then have those available for whether it be magazines or other internet sites to have the photos licensed. Ms. Radzikowski has been fairly outspoken. She has, in fact, she recently published an article in New York Magazine about the fact that she feels that her privacy has been consistently invaded. Shortly after these photographs were taken, Ms. Radzikowski took one of them, and if we can go to the next exhibit, please. You'll see at the top, it says Exhibit B. These are taken from the court filings. Exhibit B shows the photograph that Ms. Radzikowski uploaded to her Instagram stories platform. As many of you probably know, Instagram stories are automatically deleted after 24 hours. She added a caption to the photograph that said, "Mood forever." And during her testimony, it was fairly explicit that this was her way of expressing that she feels that her life has been and her privacy has been invaded by celebrity paparazzi, including Mr. O'Neill. Notably, when we're looking at this particular photo, you'll see that her face is covered. It is fairly difficult, if not impossible, to tell who it is. She's not wearing any clothing that has any label on the outside. And essentially, this photograph was not really primed to be used by fashion companies. And that's something we've seen in some other similar celebrity paparazzi photographs, where if a plaintiff is trying to allege damages or there's an issue as to the value of the photo, oftentimes it has to do with whether or not the photo could have been used for sponsorship purposes. Ms. Radzikowski uploaded this photo. She added the caption, and not long thereafter, Mr. O'Neill, who actually follows Ms. Radzikowski on her Instagram, saw that the photo had been uploaded. With obviously, I'll get to it in a moment. There are some arguments about how the photograph is used, whether it was fair use. And he contacted his attorney, Mr. Leibowitz, and they shortly thereafter filed a lawsuit. And we are in the process of, we went through a discovery phase. We filed a motion for summary judgment. And I will quickly run through what the arguments are and then stop at a couple of quick points. First, we have some arguments about whether or not the copyright had been validly registered. And I'm not going to get into that because it's probably the most boring part. The next argument had to do with whether or not The photograph itself was such that it showed any indicia of any kind of artistic expression. And this is a tough one because, as Ron pointed out, when somebody takes a photograph, there is sort of a presumption of an automatic copyright. We argued, and I don't know if it'll be successful, but we did argue that by virtue of the fact that he happened to be just following her on the street, there's no, minimal, if any, efforts to deal with lighting, cropping, or doing anything else that you might imagine would be associated with some actual creative expression. The argument that we have made is that this photograph is not entitled to copyright protection because it is so of the moment as opposed to anything that involved any thought process of Mr. O'Neill's that copyright should not attach. The law is very mixed on that. I do want to talk about fair use. So we have argued that because of the way that Ms. Radzikowski had used the photograph, that she had taken it and made it into something that transformed the expression of what you're looking at here into a separate photograph by adding Mood Forever as her own expression as to her feeling, and as she would say, a millennial expression of her feeling that her privacy was being invaded, that it transformed the nature and the use of the photograph. And lastly, we argue that the plaintiff is not entitled to damages, neither any kind of actual damages, because first of all, the photographs that were in the set had netted a total of about $2.50. And this particular photograph had netted, well, he could not testify that this photograph had netted anything to him, therefore that he had not actually sustained any recognizable loss. And then on top of that, they asked for statutory damages under the Copyright Act. And this is also it's a little too complicated for today, but we've argued that if you don't have actual damages, you can't suddenly dream up statutory damages. And in any event, they hadn't met the statutory requirements for statutory damages. We've also sought summary judgment on the basis of our affirmative defense under Section 505 of the Copyright Act, which is that a plaintiff who brings a copyright action in bad faith can't be liable for the defendant's attorney's fees and costs. So bringing this now back to the topic of consideration today, celebrities, social media, and paparazzi, and who owns their image. Well, I think Ms. Radzikowski has been fairly clear in writing her New York Magazine article that she believes that she has a right to her image, and there is a legal basis for that. Under New York law, there are times under the civil rights law where if a person's image is used for unauthorized purposes for commercial gain, that can be a violation of the statute. On the other hand, you have celebrity paparazzi photographers who generally have a First Amendment right to take photos. Now, if you do a survey of the states and the law, you'll see that certain states, particularly California, can be more protective. New York does not have as stringent laws about how a celebrity paparazzi photographer, how close they can get and so forth. I think what makes this case a little bit unique is that you have a situation where you had the celebrity, taking the photo and even assuming that the photo had a valid copyright, which I think is questionable, and then putting it on their social media platform of themselves, whether or not they would mean that they're allowed to use it. It's, after all, it is them, and this is Ms. Radzikowski walking down the street. Why shouldn't her image belong to her? Well, the answer is that it's really a tension in the copyright law, because you have a situation where a celebrity photographer takes a picture, perhaps has a prima facie case for copyright protection, and in order for that to really be overcome, you have to show that there is no protection to the photo itself. And the fact that the celebrity may have not given consent is not in and of itself going to generally carry the day. I believe It has been argued before. There was a similar case with Gigi Hadid, where she had argued that there was an issue of implied consent, which is a little bit beyond today. I don't know if somebody else will cover it, but on the other hand, I think that the fact is that where we stand today is that for anybody really who uses content and does not seek a license, and by claiming that it is their own image is not going to in and of itself going to carry the day under the current state of the law. I think it's far more nuanced than that. And I think that, this case is an example of the fact that we probably have not yet gotten to the point where the law has entirely caught up with social media, and particularly with respect to the use of a celebrity's image. So I will stop there. And of course, I'm be happy to answer any questions, but I know that we have some amazing panelists who also get a chance to speak.
Thank you, Dan. So I'm going to turn it over to Nancy, who I undersold a little because she is in fact also a litigator and a mediator, works in mediation to resolve these disputes. So Nancy, I'm sure you've seen similar fact patterns or very close fact patterns in your litigation. Any initial reactions to that, or to, I guess, my introduction of Dan, if you'd like?
Sure, and thank you so much for having me. I love this subject. And yeah, I wear many different hats, which is probably unique, because I have represented a trade association of all the stock image libraries for many, many years, as well as individual photographers, as well as models, as well as publishers. So I've sort of seen the whole 360 world here. I don't think things are that unclear. I think they're actually fairly clear. I just think that there's a lot of perception of what personal privacy is that the law doesn't recognize as a real tort of privacy. So I think it's always clear that there's a distinction between the photographer who takes a photograph, whether it's a street photographer that gets permission, or it's a photographer who does a portrait. There's a whole different body of law that permits the photographer to display, reproduce, and distribute the photo. And for anything that I call sort of First Amendment rights, they don't need the permission of the subject. And that's freedom of expression. And that would include just the use when the photo's the product itself. So if it's a print, if it's a fine art print, if it's in a book, if it's anything that's not trying to sell another product or service. The subject has rights of privacy to their image, but because we have a really strong First Amendment that the right of the public under the newsworthy exception, as well as the right of the artist, the photographer, under freedom of expression, really limit the subject's rights in many situations. So, for example, I had the crazy case with a photographer who took pictures of the neighbors out the window from the other side, and the neighbor sort of has a sense of social privacy, as well as this model does, that there's a sense of social privacy. But really in the US, it's pretty simple. If you're in a public place, someone can take your picture. Now, California might regulate how you take it. So if you're in your backyard, you can't use super high powered lenses. New York doesn't regulate how you take pictures, but it's still, if you're in a public place in the US, someone can basically take your picture. And that is, I think, where celebrities get upset, is because there's an incentive to follow them around and take pictures of them, because those pictures sell. What I think is really dangerous is trying to say that a photograph doesn't have originality because you've taken it in the moment. There's a case, Manenberg Coors, where Judge Kaplan, who I think must be a photographer, or has some interest in the arts, because he found originality in 3 different ways. And one of them is really in timing. And my fear is if you try to say, well, because you didn't do anything but snap a picture, that there's no artistic merit. I mean, I think every photographer has an eye and they see something and they frame it. If you looked at my iPhone, I have like the worst pictures except for one of my dog because she's cute. But, you know, news photographers, they're in the moment. That's all about news photography, street photography. Some of the best photographers that are now considered, you know, fine artists that are sold, you know, have been street photographers. So I think the fact that you took the picture of her on the street doesn't mean it doesn't have copyright protection. I think some of the problem is people choose to enforce pictures that maybe should not, and may start making some bad law. You know, and I've dealt with Leibowitz many times, and there's sort of no judgment there about when you should go after someone and when you should not. But there's no like absolute right of a celebrity to use a picture taken of them. And I think it has to fall under fair use. Like, I don't see a strong implied license argument. And I think it just, you know, would have to fall under fair use. I mean, and I just, you know, those are sort of the broad outlines.
So, you know, speaking of licenses, right, Angie, that is your domain in many ways. So kind of your take on it's kind of nice. We have like two very different perspectives from Nancy and Daniel. So you get to decide who you're leaning to or find the compromise between them. What do you think?
Right. So just to give you a little backstory, I was at Condé Nast for 13 years, and my responsibility was business development, mainly licensing our content to manufacturers, third parties, and other mostly international publishers. So whenever we had, you know, a magazine published under the Condé Nast portfolio, my job was to see how we could maximize that IP and really monetize it. So with respect to the celebrity and paparazzi or photographer relationship, I would say that sometimes and oftentimes now, you find that photographers have a very close relationship with a celebrity or a social media influencer. And sometimes they are working in tandem where one is letting the other know where they are at what time. And so if they have a very close symbiotic relationship, no different than, say, the UK tabloids and the royal family, they are working together to create buzzworthy, you know, photos or content. So there is that going on oftentimes with street style photographers and social media influencers and celebrities. But with respect to the monetization of what's happening really in practice is, you know, if there is unauthorized use of you know, a photo, say you are letting a third-party publisher, say, publish, you know, the Indian version of Vogue or the French edition of Vogue, you're hoping and you are putting into an agreement and allowing for the rights that this third-party publisher is going to use that photo in the same manner and vein and in the same kind of, I would say, production as the original use of that photo. But, you know, it's really up to you to audit and make sure that that third-party publisher or whomever is using that photo in the intended use or what was to be intended. So I think based on the business of licensing these photos, whether you're licensing them from a publishing firm or licensing them from a place like a Getty or AP or Splash, you want to, you know, what publishers are doing, and also celebrities and social media influencers are doing. They're just, you know, picking the photos, they're paying their $300 or $1,000 for reuse, and they're going on their merry way to reuse that photo. But in this instance, you know, I would say it's really difficult because, you know, had, say, Emily Rakowski, had she accredited the photographer, could that have led to a different result? Who's to say, right? Because oftentimes what we're seeing is, the lack of accreditation leads up to a lot of the lawsuits that are taking place, or the I guess, the battle between the subject and the photographer.
Yeah, and I know that Dan kind of glossed over the registration issue because, labeling it kind of the non-boring part. Obviously, for me, an academic, I'm like, no, there's so much there to discuss about like the timing of things, and did she post it before it was registered and all that. But I guess for you, Julie, to get a word in before I really open it up to the whole panel. What I'm hearing from Dan is a question of the originality of the where are we drawing the line of originality for copyright. And Nancy says, look, it's very clear that this falls within the scope of originality. And I know that you've been kind of thinking about, is this still the same correct test given how easy it is to take a photo now as it was even 10 years ago, right? With the advent of smartphones where the camera is with everybody, should we really be rethinking where that test lies? What do you think of that, Julie?
Absolutely. So I do think we're at an interesting point. As Dan said, his case is very interesting, and it's special, I think, in that it's gone quite a bit farther than a lot of the other cases. There have been so many of these cases. And as a journalist myself, I'm selfishly very excited by this case because it's giving us some answers, I think, and some arguments that may have been alluded to in other cases, but never actually made it that far. So I selfishly all the time hope that it just doesn't settle, so that we can watch it play out a little bit longer. I was thinking before the panel back to April 2017, when one of the first cases in this space kind of caught my attention, which was when I think it was Exposure Photos, another paparazzi agency, sued Khloe Kardashian, and that case rather swiftly settled. She did kind of give us some information after the fact by saying she had to pay a lot to settle. I'm not sure what a Kardashian deems to be a lot of money. But I think that, against that background of so many cases and, the impact of COVID, which has in many ways shifted kind of who can be a paparazzi, who is a photographer, is interesting because we are seeing, well, one, I think that now with an iPhone or, anything, anyone can be a paparazzi. And it's my understanding that celebrity specific websites like TMZ or whatever will gladly pay a layman photographer that might just happen to be at the right spot in the right time, at the right time with an iPhone, in exchange for those photos. But then we also see it in a really professional capacity where models are on the other side of a FaceTime or Zoom call, helping to take the photos or styling the photos, because stylists and photographers and makeup artists can all be in the same space, in the same way, at least, as they used to pre-COVID. So I think that there are all of these forces that are asking questions about originality and also the potential for maybe joint authorship or, what any of that means now with so many changes at play.
Yeah, thank you. Yeah, that's a very good point, right? That nowadays in the COVID era, right, there are certainly a lot of photo shoots where basically you mail everything to the person who will be the subject of the photograph and say, okay, set it up like this, and we'll take we'll have the photos taken, and then authorship sounds like it almost shifts under the old rules. But I guess, Dan, bringing it back to you, giving you a chance to kind of respond if you want to anything. I mean, one of the interesting things that Nancy said that I'd love to hear your thoughts on is that, there is a chance that bad law essentially is going to be created around fair use and copyright if certain actors continue to behave badly. And this, in your case, might actually be an example where the law shifts, not necessarily because we think that's where copyright belongs, but because instead there is a lack of other areas of law to account for the privacy interests that your client was suffering from. Do you think that that might occur, I guess, either in your case, or is that what you're seeing in this, that some of the shifting of what is fair use is occurring because of these kinds of actors?
Well, I respectfully disagree with Nancy. I don't think that, I think it's a process that is going to take time. I think that I don't expect there to be bad law. What I expect there to be is that the fair use factors probably will be developed further to fit, within the ambit of what is going on social media. I mean, I'll by way of example, people are all the time are in the process of taking photos and images from social media and reposting them without giving attribution, and certainly without seeking licenses and consent. In the case that we're discussing, there's a fairly different situation where Mr. Rajkowski had in fact not only had added the caption, but by adding the caption, as we've argued, changed the nature of the photograph from a celebrity paparazzi run-of-the-mill garden variety photograph of somebody walking down the street holding flowers over their face to to a commentary on the invasive nature of the paparazzi. And I think, one of the things that I didn't mention before, but probably should raise now, is by virtue of the fact that Ms. Rajkowski is holding the flowers over her face, first of all, as I said before, you can't obviously tell that it's her. But secondly, that in and of itself has meaning to her, because it's essentially she's shielding herself from the paparazzi. And I think that, to me, that does transform the photo from what is a paparazzi photo to her making social commentary. I think that what I do think is really going to be critical in times to come is the issues of reposting, and not only celebrities reposting images, but people reposting images from wherever they find them. And obviously not every reposting which doesn't have a license or fair use is going to end up with a lawsuit. My question is, come 3, 4, 5 years from now, is the law going to get in certain ways so flexible that the fair use factors begin to encompass the possibility that something of a more of a de minimis usage is going to be deemed to be fair use? Because at a certain point, you're not going to be able to be aware of all the different ways that social media is going to reuse images. And this is not just germane to paparazzi, but just everybody who goes on Instagram and takes different photos and reposts them. So I think that what we're going to see is, I think over time, frankly, Mr. Leibowitz, may or may not be filing more cases in the future. He has some, issues he's dealing with in front of various ethical bar and grievance committees. But, these kinds of situations, I think, are going to force the judges, the judiciary, to have to develop the fair use factors, which are, while they're codified, they, are very much judge-made law, and to have to, start to probably draw lines as to whether or not just, mere reposting of images is going to be is going to fall within fair use, or whether it's going to be a breach of the law, every time it happens.
Yeah, thank you. And, on that front, right, it is worth pointing out that there is a concept of de minimis copying in copyright, although it doesn't currently encompass the kind of copying that occurred in this case, I don't think. But in terms of the reposting, right, that Dan is talking about, Angie, I want to turn it over to you because, right, there is the concept of memes, right, and that is taking something that's in the moment, a cultural, very recognized form, and as Dan describes here, right, like transforming it into a different message potentially. And you've encountered this idea, as has Nancy. And so it'll go Angie and then Nancy talking about memes, and maybe one meme in particular, because I think you know who I'm talking about.
Sure. So if I can share my screen, Claire, yes, thank you. Do you see my screen?
Not yet.
Oh, okay, I'm sorry. Let me, okay. Okay, now can you see my screen?
Yes.
Okay, great. So this, I think many of us are familiar with the Bernie Sanders meme. It was of him at the inauguration ceremony. And, to Dan's point and to your point, Ron, the idea of reposting or taking a very popular image and using it, as form of humor and just being kind of what we call in the media world like FOMO, right? Like the fact that we all recognize this meme. It's like we know what's going on. We're part of this kind of national and international dialogue. The reason why I brought up these particular images is because when you talk about a meme or a photo, oftentimes we think about what's happening in the US, but really photos, because of just the nature of the cyber world that we're living in, they are quite internationally, I guess, distributed, or there's exposure internationally, right? So I have this image on the far upper left corner. That's the original image. And just for fun, I Googled Bernie Sanders meme in Korea, China, Japan, and the UK. And these are the images that popped up. So, and they're created by non-Americans. So it just goes to show, while we think, oh, somebody in the US is reusing this particular image, I think it should be thought too, somebody in China is reusing this image, somebody in Japan or wherever else in the world is using these images. So it just kind of reinforces this idea of like, what does reposting mean and where exactly are these images being distributed?
Yeah, and so Nancy, either looking at this internationally or looking at it, within the US, where is the line between like a meme that doesn't have to really get the license and the licensing schemes that you deal with for your clients often?
Yeah, well, this is really, I think, a great example of those that are managing the rights of this photo, really understanding the line between what is social and personal use and what is commercial use. So this image was taken by an AFP news photographer, because you, of course, had to have credentials to get to the inauguration. You couldn't be a paparazzi. And it's in the US, and that was AFP International there. Many offices based out of France. It's distributed through Getty Images in the US. And the only licensing of it was really for commercial use. And it's sort of the difference between a trademark and a copyright. With copyright, you can choose what uses you think are fine. And if it's a meme that's being shared socially, then no one is going after these. And I know that very recently, the CASE Act just was enacted, which is a small claims for copyright infringement. And those that were against it keep saying, well, everyone's going to go after, grandmas with memes, but really no one wants to go after these personal uses. I think it's understood that this is just becomes a social event. Everyone is sharing it. But if a commercial publication wants to do it, they license it. And in fact, Getty Images took all the licensing income from it and donated it to Meals on Wheels in America. And you know, AFP does use enforcement for its images, but it doesn't, you know, doesn't choose to go against the use of these types of memes. You know, if someone wanted to start selling a line of T-shirts with the Bernie meme on it, that would be different. Or, you know, someone was using it for advertising. So I think that, you know, a Getty Images and an AFP and those who really understand and manage copyrights and manage particularly news photos, sort of, you know, understand where it's appropriate that someone has a license and where, you know, it's not. And sort of hard to just really want to expand just fair use broadly to say that any reproduction would, you know, be a fair use if it becomes a meme, because it's really how is it being used at the end. But yeah.
And we certainly, right, we have cases separate from the celebrities like Richard Prince, the appropriation artist, who's kind of also pushing for us to better define what is and is not a fair use in this sphere.
The idea of a hashtag transforming has been argued. There's no definitive answer. I know that Fox News, one of their shows, did a social media post where they put a photograph from 9/11 next to the Iwo Jima and compared it, and they just put "never forget" under it. And there was a motion for summary judgment, which was denied, and it said it was too close. It was going to go to a jury, so it settled. And with Richard Prince, he basically blew up pictures and just put gobbledygook underneath one of them and said that was transformative. So it really does need to have a different message, and maybe the one where you're holding the flower in the face might be a different message. But I think just a hashtag alone, it'll probably isn't sufficient, because you're still using the photo for the underlying purpose, which is an aesthetic purpose.
So I do note we only have about 15 minutes left in our panel. It's crazy how quickly time has gone by. We do have one question posted to us, but audience, you are welcome to post more. I'm going to push it to Julie to answer it first, and I will basically summarize it, which is, you know, and I think, Julie, you might be a good person to ask because you are a journalist, right? And this is kind of the question is phrased of, you know, would the law handle this situation differently if a celebrity were to sue an Instagram account such as, and I'm going to butcher this, Dumois, which solicits anonymous layman celeb paparazzi photos, rumors, speculation, right? How would this then interact with copyright law? The idea that, you know, it's a celebrity in that moment trying to assert some rights over not the photographer, but a third-party publication. I think the answer is pretty straightforward, but I guess from your perspective as a publisher, is there more of a question there?
I'm not sure if I fully understand the question. I'm trying to read it here.
I think the question is, you know, who can assert, to some extent, who can assert a right? Right? Does the celebrity have the ability to assert a right under people who solicit paparazzi photos? I guess, but not, you know, if TMZ was an Instagram account, right? To what extent would the law protect TMZ or the celebrity in that moment?
I mean, isn't it the author that has the exclusive right to take copyright action? I mean, I suspect that maybe there's a Section 230 element to that answer, but I don't think that we need to go into that right now. I also think that, you know, some element of that is, of course, probably news reporting, which complicates the answer, but also raises fair use issues.
Yeah, so let me ask, you know, Nancy pointed out, right, that the Bernie meme was taken by I think, Nancy, you phrased it as like, you know, a sanctioned photographer almost, right? Somebody who's allowed to be there as opposed to a paparazzi. And I guess my question to you, Julie, is like, where do we draw the line in labeling somebody as a paparazzi versus, you know, professional photographer, to the extent that that might inform some of the discussion we're having here today?
I mean, I'm not sure that it necessarily, the distinction matters so much. Maybe it would have in the past, but I mean, if we think about one of the recent-ish paparazzi cases that I can think of, Kendall Jenner, for instance, was sued for posting a video that she didn't take of herself. And the video was taken by a lay person that just happened to be outside of the Balenciaga store when Kendall was walking outside of the Balenciaga store. This was not an individual who was, you know, a paparazzi photographer. You know, she wasn't affiliated with Splash News or Exposure or anything like that. I'm not convinced that the distinction matters anymore or is relevant, given that, one, we're all really inside. So how busy are paparazzi photographers? But also anybody, I really think, can be a paparazzi photographer. I mean, I think that it was interesting after Khloe Kardashian was sued, the Kardashians kind of said, okay, we're going to get our own photographers now so that we're not sued over these sorts of things. I guess that didn't quite work out for them.
So the other element of this, right, as Dan originally pointed out, right, there's very little redress for the celebrity in the moment, given where the laws are. And Nancy kind of pointed out, right, that right of privacy doesn't cover what's really being requested. Well, I'm curious if any of you, you know, have been looking into the right of publicity, and I didn't prime them in advance, audience, so who knows what kind of answer I'm going to get for this. But, you know, here in New York, you know, within the last 3 years, we actually amended the right of publicity, but we didn't make it stronger to take into account these kinds of situations, right, where a person is walking down the street. It's still very much maintained to whether the person is being used to endorse a product. I guess, why do you think that is, that you know, New York has chosen not to go the same route as California, as Dan pointed out, in terms of further protecting the potential subjects of these photographs? And I leave it open to any of you to comment.
I don't know the answer to that question. I imagine that you know, with you look at any law, you have to look at the legislative history and see, you know, who was arguing what sides, and, you know, who was being benefited as a result. I would say that not unlike the situation with reposting, I think that there's a I don't know that I have to admit that this is a little bit of speculation, but I do believe that there is a point at which the legislature does not wish to open the floodgates to lots of litigation. I think that if you were to create, maybe the thought is, and I don't know if this is the case, but maybe the thought is that the stronger protections that exist for a person to sue on their person, you know, their image, that is they're creating a sort of a legislation supported plaintiff side floodgate of litigation. Maybe that's one reason. I don't know the answer to the question, and it's a good one. Maybe Nancy.
Go ahead, Nancy.
So I've been following New York right of publicity law for years, and typically every June I have to run to Albany because the Screen Actors Guild generally wants to have a very broad right of publicity bill that will affect those who have died in New York. Because New York was really unique in most states that when you die, your rights die. So it was always a private right. And it really sort of, it's been there since 1904. And so when you died, your rights died. And they finally basically wrote a law with the motion picture industry. And it was very careful to protect all these First Amendment rights and expressive works, because there's docudramas, docuseries. And so the law that we have now, which now gives protection to those who died in New York and domiciled in New York, has very express carve-outs for expressive works. And the other issue that the Screen Actors Guild was really interested in was deep fakes and digital avatars, where an actor would be replaced by a digital substitute, because they want to make sure actors keep getting jobs. And then, but the issue was really sort of the pornographic deep fakes was what's really bothering them. I don't think anyone's ever going to touch street photography, because the First Amendment would have it overturned in a moment. Because I mean, if you're in Europe, your rights are sort of equal to what people want to know. In America, it's basically, we don't care if the public wants to know more about celebrities than the economy, it doesn't matter. But if the public's interested in something, it's a public interest. So the rights of a celebrity to walk free in the street, though it must be really stressful if you're a celebrity, is really sort of becomes lower than the First Amendment right of freedom of the press. California prevents people from using intensive equipment to look like if you're really in your own home behind a wall. And I think probably drones will get into that area the most soon, but you know, what can happen with drones going over someone's house? And in New York, we don't really regulate how things are protected. There's some protection, so you can't be, you know, in a changing room somewhere and someone have a secret camera. But I think that, you know, the changes to New York law have been really based on trying to expand it to cover those who really the commercial uses of a celebrity's likeness after they die, and to prevent actors from being replaced by digital avatars.
So we do have a question from the audience. I guess one person really wants to push you, Daniel, on your definition of where originality starts and stops for photos, right? They're saying, I take photos, I decide on the angle, the framing, and the emotions of the moment. Even though we now have smart cameras, why wouldn't these actions constitute an expression that is protectable? I think, you know, based on the discussion, I don't think you want to say that isn't protectable, but I'll let you, right? I won't put words in your mouth.
I thank you, Ron. Well, you know, I'm down on the record as to arguing in a certain way, and I heard Nancy, you know, make some good points about the argument. I recognize that there is a line there. It is to start saying that any photograph doesn't have you know, expression is very much you know, could be controversial. I think that and this also actually goes back to one of the earlier points. You know, our Mr. O'Neill, the plaintiff in our case's testimony was that he was a professional photographer, that regardless of being deemed, you know, a paparazzi was essentially irrelevant, but he saw himself as somebody who was you know, an artist. You know, I think that when you are, in this case, following somebody up to the outside of their apartment building, sort of chasing after them, and you take 9 photos in essentially a millisecond, and your intention is simply to try and capture their image before they go inside their home for the purpose of selling it. I do think that there are questions that arise as to whether or not this is a photo that is of, you know, really has creative expression. And there is case law that goes in, I would say, both directions. I'm not saying, again, would never want to usurp the function of the judge and say we're going to win this argument. But it was done in such a haphazard, slipshod, and intrusive manner that I think the question, it has to be asked at what point, is it really creative? At what point is it simply, pure profit-making motive and with a total disregard for somebody's, privacy? But I, as to the person who asked the question, they, use their iPhone to take pictures, and they tell people to get in the photo, and, maybe they change the exposure, and maybe they've, trying to get it at a certain angle. They're not, running after somebody down the street. I know it's a fine line, but I think in that, I probably would say that does have more of an actual expressive intent. So at that, I have to leave it at, what I've put in papers.
Yeah. So I want to follow up on something that Nancy said with regard to the right of publicity and carving out, the idea of documentaries, docuseries. I mean, isn't one way to look at something like a social media platform run by the celebrity, or like an Instagram run by the celebrity? Isn't that just like mini documentary, docuseries kind of moments of the person, like as an autobiography, this is my life? And if it is, why doesn't the same protection that we would apply to a documentary not apply in that moment of the celebrity showing themselves in, their own platform, right? Like if somebody took a photo of me and I want to comment on the fact that I was, at whatever place on whatever day, should that just be considered the equivalent of, putting the image in a documentary? What do you guys think?
Well, when you put an image in a documentary, the New York right of publicity law is dealing with the likeness issue, not the copyright. Mm-hmm. So when you're putting your own photo in your own mini documentary, that's dealing with the likeness right, but not the copyright issue. So then you get back to, is this something that would be permitted under copyright law? Because when you make a documentary, you need rights, the underlying material, and it's just, do you need permission from the subject?
That's true. Yes, although, documentaries often can bypass the licensing, right, of copyrighted images because of fair use.
Because of fair use, you can, right? But it's generally when the picture is not just illustrative, but it's making a different point. And my firm does a lot of entertainment work and a lot of documentaries, and I get pulled in to review everything at the end to make sure everyone did it right, which is one of my favorite things to do, which is one of the third hats I wear, or fourth or fifth or whatever, but it's fun. But yeah.
So we've run out of time. I want to give Angie and Julie a chance for final thoughts. Angie, any final thoughts you'd like to share?
Well, I think, you're bringing up a documentary aspect of, celebrity photos or them posting. Last I checked and calculated, there were, of all of the Kardashians combined, they have 1 billion plus following of all the Kardashians combined. So when you think about, how many followers they have and the types of posts that they're posting, oftentimes it's more for, commercial, the intent is for commercial purposes, meaning if they post some handbag or article of clothing, oftentimes that piece of that article sells. So I think it's interesting. It's if there is that argument for, say, this is my life and this is just a snippet of what I'm doing on that kind of documentary angle, I think that's a nice interesting kind of perspective. But I think a lot of these social media celebrity types, they know exactly what they're doing, and there's huge money to be made, and so and it's the law is we'll see what happens as far as how much the law will evolve based on the different new platforms developing.
Julie?
I think Angie makes good points there. Even I think for posts that aren't explicitly commercial, there are arguments to be made about just maintaining a social media presence, which can then lead to other opportunities for monetization based on how many followers you have and this, that, and the other thing. And I think that there's a lot of interesting issues in this space, whether it's paparazzi photos or, embedding of photos, just a lot of interesting topics when it comes to copyright. And it's striking to kind of see them evolve as our use of imagery rather swiftly evolves.
Yeah. No, it's certainly an ever-evolving part of the law, it seems. And Dan, I think we'll all be watching how your case gets resolved and whether or not it's followed up with an appeal. As Julie noted, I'm also hoping there is no quick settlement here because I do want to see how things turn out. But I leave that to you and your client to figure out what's best for your client in terms of resolution of this. I want to thank all of my panelists today. This has been a wonderful discussion about this issue, and I hope you have been attending, have been enjoying it. We have run out of time, so I will leave it to Claire Marie to tell us what we do next. Claire Marie.
Hi, I just wanted to say thank you to all of our panelists, especially this last panel. I wish there was a good way for the attendees to give you a round of applause, but unfortunately there's not a great way for them to do that. So I'll give you a virtual round of applause, and thank you so much for joining us. It's been a great event today. I'm going to put in the chat, just as a last note, information about CLE and who to contact and what form to fill out. But yeah, thank you again. This has been, a very different year to plan a big event like this, and the panelists and our moderators have really helped make it very easy and very exciting, and brought a lot of enthusiasm for this event. So thank you all again.
Thank you, everybody.
Thank you.
Thank you.